and the victim girl remain to be examined. Full stop. It is submitted by learned counsel that the prosecution has taken 4 dates for examination of the victim. Full stop. We'll call for the scan,
Yes.
scan record, scan TCR comprising case diary and charge sheet, and copies of other relevant documents like depositions.
Yes.
Right. This is the matter on when it will come
It-
from which court?
District and Sonitpur you'll also.
Huh?
Sonitpur.
Sonitpur. Sonitpur.
82 also.
Huh?
18.
And will be late for you. 18 or let it be on a little earlier, 16.
Not late.
Deeply of regulars.
Supplementary 46.
May I please, your lordship.
Yes.
This is regular bail application,
Tell me.
lordship.
Yes.
Lordship.
Yeah.
And
Tell me.
lordship and the
Arrested on 2nd, no?
lordship,
Second.
the FIR will find lordship page number 10, lordship. And may I read lordship, very small FIR, lordship.
Yes.
Lordship. Would you respect it is back to state that I am the manager of a GIA communication company. We have received the tender from the Government of Assam by so and so number and to hanging holding board under the all over bridge of Guwahati city. Accordingly, we have hanging all the holding board and also hanging holding board under Garsuk flyover within the jurisdiction of Garsuk police station. But today on 1/2/2026, we came to learn that 2 persons has stealing the hoarding iron under the Garsuk Sariali flyover. As soon as we informed the Garsuk police station, then the Garsuk police caught the 2 persons along with the e-rickshaw bearing registration number so-and-so while they loading the e-rickshaw and seized the hoarding iron. Thereafter, we interrogated apprehended accused. They introduced them as Azizur Haq and Prosenjit Das, lordship. And they said, and they also said that stolen hoarding iron has sold in a dam at 6 months. So, my lord, and I am the owner of the dam, lordship, and escape materials, lordship. And for a moment, lordship, kindly, this is the notice 48 notice up to me, lordship, and one thing is very much clear. And so, my lord, and I am the lordship, and I am appearing in the seated examination, lordship. Kindly come to page number 24, moment, lordship. Page number 20. Annex 4, lordship. And I'm the and here the name application number so and so, and the examination will be held on 8/2, lordship, on Sunday, lordship. And one thing, lordship, and
He's arrested already.
lordship arrested, but already been recovered, lordship. This holding, these are the postal, lordship, in the backside some iron, lordship, and these are 2 persons they have sold out, and lordship 48 notice and ground of arrest number 1, lordship, is very much clear, lordship. And তদন্তৰ সময়ত এই গোচৰৰ অভিযুক্ত আজিজুল হক and Prosenjit Das, they are also arrested, lordship, and চুৰি কৰা সামগ্ৰীবিলাক আমাৰ আপোনাৰ ল'ৰা, that is the notice receiver বাহাৰুল ইছলামৰ স্ক্ৰেপ য়াৰ্ডত বিক্ৰী কৰা বুলি স্বীকাৰ কৰিছে. So, my lord, I am running the scrap metal shop since long back, lordship. And lordship, and
But whether he knows or no, anyway.
lordship, already been recovered, lordship. And now, lordship, and for page number 20, lordship, the examination date of examination 8/2/2026, lordship.
Central
And he will,
teacher.
lordship, and he will be appear in the seated examination, lordship. So, my lord, any interim protection may be at this stage, lordship, and his career is there. Otherwise, he is not involved at all, lordship, in the theft.
He is the son of this person, Baharul Islam.
Azad Hussain, lordship.
So
Azad Hussain, lordship. And father and son, they are doing this running.
both of them are arrested.
Lordship arrested.
Both father and son both
Father
arrested.
is not arrested, lordship. And lordship, and the other 2 persons, lordship, Azizul Haq and Prosenjit Das, they are arrested, lordship. Kindly come to
They are arrested, but Baharul Islam.
page number 17, lordship, for a moment.
Okay. Apunar Lora.
Lordship, my father, this notice is her,
So
Okay.
notice is to the father.
father.
Okay, 48. 48 notice.
Page number 17 is the lordship and the forwarding reports, lordship, and 16 and for 17. And another 2 also arrested, lordship. So, my lord, my career is, lordship, and I am no way connected with the theft, lordship. And this is the poster and holding poster, lordship, and the
You okay?
He's a
Owner.
owner of the scrap
Ah.
business. Other things is the
But scrap dealers do buy different kinds of things, but if he knows that it's stolen, then it's implicated.
Whether
But
he-
anyway, let him appear for the exam. So F. Hawk Learned, counsel for the petitioner, and DP Goswami. 483 BNSS. Gorshuk PS case number 26 of 2026 under so and so. He was arrested on 2/2/2026 and FIR was lodged on 1/2/26 with the allegation that the informant is the manager of a firm who had secured a contract from the government for putting up hoarding boards on overbridges of Guwahati city. And later on the said date, 2 persons were found stealing such hoardings, and they were apprehended as Azizur and found as Azizur Haq and Pranjit Das, and that it was revealed from them that the stolen hoarding was sold in a depot at 6 Mile. The value of the stolen materials would be about 3 lakhs as alleged, as stated. Full stop. The petitioner is stated to be the owner of that scrap shop, and he was arrested during investigation. Seeking temporary bail at this stage, the learned counsel draws attention to a document annexed as Annexa 4 at page 20, indicating that he has an exam. He has to appear for Central Teacher Eligibility Test 2026, and date of examination is indicated as 8/2/2026. Full stop. Call for the case diary from the concerned police station, however, with a view to enable the petitioner to appear for his exam at this stage of investigation. It is directed that in the interim is allowed to go on bail of rupees 30,000 with one surety to the satisfaction of the concerned learned court, CJM Kamrup
Judicial,
Metro,
Mr. Kamrup Metro.
and subject to the condition that he shall cooperate with the investigation, shall not hamper or tamper with evidence. This is the matter on,
23/2.
can we give a little earlier,
Earlier than what, okay, 18/2.
16 to or 18?
No, not 16/2. Deeply obliged.
17 is holiday. 17. No, 17 we have not fixed anything. 17 is a holiday or something, no?
No.
17 to,
18.
okay, 17 to.
Lordship. No. Obliged, Lordship. Deeply obliged.
You take this back, you can take it back, or should I keep it? Should I keep it here? I'll keep it.
Motion may be item number 3.
May it please your lordship.
Maybe.
Lordship, this is an anticipatory bail application. The petitioner lordship has very unfortunately but unknowingly and innocently become associated with one allegedly repeat offender for 1 day lordship, because of which now he has to appear before this honorable court. Lordship, I think the documents will show that he is innocent, but firstly, I would like to take your lordship to the FIR at page 15.
Yes, I'm on 15. Let's read it then.
Lordship, if I may read it.
Yes.
With reference to the subject cited above, I have the honor to state that on 28/5/2025 at approximately 12:30 AM, information was received from the additional superintendent of police crime Biswanath that a group of dacoits was suspected to be entering the Jinja PS area with the intention of committing a dacoity. Accordingly, the information was recorded in the PS General Diary number so and so, dated so and so. Acting upon the information, I, along with my staff and battalion personnel, departed from the police station and set up a Naka checking point at Rotwa Overbridge on NH 15. In the meantime, the Honorable Additional SP Crime Biswanath also arrived at the Naka checkpoint. While the police team was on high alert to intercept any suspicious vehicle, at around 1:15 AM, one vehicle bearing registration number so and so was spotted coming from the Biswanath Chariali side. Before we could intercept the vehicle, the driver and occupants attempted to change lanes to escape. As the additional SP Crime Biswanath tried to block their way to prevent their escape, the miscreants rammed their vehicle into him, resulting in injuries to the officer. The miscreants also made an attempt to attack the police personnel, disregarding all warnings. While trying to flee, their vehicle got stuck on the road divider. Taking advantage of the darkness, they abandoned the vehicle and managed to escape on foot. search operation was conducted in the probable hiding areas for a considerable period, but no trace of the miscreants was found. The vehicle bearing registration number so and so was seized and brought to the police station for further action. On search of the vehicle, the following numbers of items to be used in dacoity was recovered: one iron clamp, approximately 20-inch length, one iron steel, approximately 24-inch, one iron da, one bent condition, iron steel, approx so and so length, one iron da. It appears that this is the act of an organized gang of dacoits, armed and dangerous, capable of causing serious harm to the public in furtherance of dacoity. Their intentions so and so were under thorough investigation. On this basis, case was registered also.
And how's the person, his name is Noor Hussain.
Yes, Lord.
What is this?
She will see what
Driver
happened.
also.
The owner of the vehicle was arrested. She is a lady.
Uh-huh.
Her bail order is at page 20. She tells the truth in her bail application.
Let me have a look.
In page 20, the last para, if your lordship may kindly.
Submit that. Registered owner. That's it.
She's simply a housewife.
I
having
was
some-
submitted most of the objections. Been. Her husband is stated to be habitual offender.
Yes. And
Student
I am the
is-
driver she had hired to take the vehicle to GMC for a day. She states this.
Petitioner directed to furnish. The driver of this vehicle.
This vehicle, and I had taken a patient to GMC. On the way back, I was only with one person, the husband, Habiz Bhuya. There was no other person in the vehicle. He is a habitual offender. I did not know this, Lord.
But the thing is that there were iron clamp, all these things were recovered from the vehicle.
These are
Iron
legal
da,
objects, Lordship.
then, huh? 2 feet
No.
iron, isn't it?
Yes, Lordship. Then kindly see, Habib Bhuya was arrested in connection with two other cases.
Hmm.
That and
He was the
I was-
vehicle was taken on hire.
No. Vehicle is of the owner. She hired me as a driver to take the vehicle.
Owner means her husband.
Her husband's wife, Lordship. Husband is the
She's
main
the,
accused, the
okay,
repeat
I
offender.
understand. She is the owner, her husband is
Is the repeat
alleged to be a
offender.
habitual offender.
Yes, Lordship.
And they had hired a vehicle. No, they had taken the vehicle and hired you as a driver.
Yes, Lordship.
Hired you as a
On a
driver.
day.
On the day of the incident.
Yes, Lordship. On the way back, this had happened. He
It
was
is
arrested.
CDB call for lordship
Mhm.
to see
No,
his
Lordship,
involvement.
there was a bailable warrant of arrest against me also by the after perusal of the case diary.
Let me see. We were reading this, no? Let me see it properly because otherwise it's a dacoity case. Release on bail. And what is the relevant part of the order you wanted to show? Noor
Page
Hussain,
20, Lordship.
page 20.
20. The bail order. There are other documents also. I'll come to those.
20, no?
Yes, Lordship.
Okay.
This is the
yes.
bail granted to
Alright,
the owner of the vehicle. Learned advocate
owner.
petitioner submitted that the accused is innocent. Last para, Lordship.
Yes.
She is simply a housewife, having no any past criminal record against her. She is registered owner of the vehicle bearing so and so, which was seized by police of Jinja. She hired a driver, namely Noor Hussain, who took the vehicle to GMC to admit a patient of serious condition, but she was ignorant about the involvement of her vehicle in crime or used for illegal purpose by her driver, and she was arrested merely on suspicion and may be released on bail. The police objected to the bail application.
No, but submission was that it was used for illegal purpose by her driver.
No, Lordship, kindly see.
Driver is the petitioner, right? So
Yes.
she was ignorant about the involvement of her vehicle in crime or used for any illegal purpose by her driver.
She did not allege her husband. She put the allegation on me.
Yes.
But see the objection of the police, Lordship.
Mhm.
Page 21. On the other hand, the IO of the case submitted its bail objection with some points, and learned additional PP also raised its objection. I've gone through the record. Most of the objections raised against the accused Habiz Bhuya, who is husband of accused Hamida Khatun, is shown as habitual offender having so and so cases against him. Page 21. Similarly, learned
She was granted bail.
he was granted bail. Eventually, Habib Bhuya was also granted bail, same objections against him. The bail order is at page 25. He was shown arrested in this case, and he was previously arrested in connection with two other cases. I've annexed the the prayer for shown arrest also, Lordship, at page 22.
When can you get the case diary? This one is really.
From lordship, short date lordship.
No, Lordship, one more order against, in respect of me, page 29.
On 9th, Lordship.
Please see page 29 for a moment. Lordship. The Learned Trial Court issued bailable warrant against me. Not the trial court, the jurisdictional magistrate.
See, you come to page 34, please, prosecution also. That bail order is there, no? Page 34. Bail order, see the last paragraph. The driver attempted to flee the vehicle and rammed the vehicle into the vehicle of the additional SP.
So that
Isn't
is
it?
the allegation.
That
What
means
I-
he was aware of this
No, Lordship,
presence
I
of
was
these
not
things.
aware. I was with the.
Otherwise,
owner.
you cooperate with the process of law when there's a naka checking, isn't it? So let us see
No,
the case diary.
Lordship, the person said that do not stop. The owner is telling me, he is my boss. He's telling me, don't stop the vehicle, turn the vehicle around. I ram it into
No.
the divider.
So I'm not convinced actually. Let us get the case diary.
Lordship,
On
if I may
10th,
show
Lordship,
page 29
10th.
for a moment. Lordship,
I don't think it's a Dacoity is serious matter. This is
but please see
public
page
safety,
29,
public
Lordship.
safety issue. And he was riding with a person who was 4 cases against him, isn't it? 5 cases against him.
Ten-
Page 30 is.
Lordship, please see page 29 once. 29 and 30. This is the bailable warrant against me.
Yes, that's okay. So initially, the court should issue always available warrant initially.
No, but this is not a trial, Lordship. This is
No,
only,
initially also.
this is,
Anyway, that is a better approach straight away, that, because the police has to.
but this was only after perusal of the case
Anyway,
diary. It
sorry.
appears that the accused
Or-
Mohammed
so
Noor Hussain
call
was
for
driving
the-
the vehicle.
Call for the case diary from the concerned police, call for the case diary of GGR PS case number 60. Will give a short date, huh?
10th,
63 of 25 under so and so. The petitioner is alleging, the petitioner is apprehending arrest in connection with this case lodged on the basis of, registered on the basis of an FIR lodged on 28/5/2025. It was long back, it was registered. no?
Yes, Lordship.
With the allegation that information was received by police regarding some activities pertaining to dacoity, whereupon checking was late and a vehicle bearing number AS02AR6078 was intercepted, but it tried to flee and rammed against a vehicle of additional SP. Later, later, some incriminating materials like iron clamps, iron steel, iron bend condition, iron steel were recovered. Full stop. The learned counsel seeking interim protection submits that the vehicle in question belonged to one Hamida Khatun,
Lordship.
and she has been granted bail. Her husband is implicated as a main accused in the case and stated to be a habitual offender by the police. It is contended that the petitioner is a driver and is innocent, and that the wife, the husband of the vehicle's owner had hired the vehicle to take one patient to GMCH. Full stop. Full stop. However, it's reflected in one of the order of learned court below that as per the prosecution, when the vehicle did not stop and tried to flee, and in the process hit the vehicle of police officer. Full stop. The same is also stated in the FIR. Therefore, at this stage, I deem it fit only to call for the case diary. To stop, call for the case diary accordingly of Jinjia police station fixed on short date,
On 10th, Lordship.
10/2.
That's okay.
Let's see the FIR and then we'll decide, right?
Item number 12.
In this case, actually, madam, there is no FIR, but, madam, the petitioner reported also is a government employee, madam. The deputy superintendent-
There's no FIR,
There is no FIR, but
all women police station.
all women police. Madam, my wife lodged a complaint against me, madam.
Oh.
And thereafter, my lord, police called me over phone. And, after filing this case also, madam,
Mm.
police visited my office also, madam. So, but they have not registered in case, till that, madam.
Mm.
But there is apprehension that if I go there, they might arrest me, but they are calling me, madam,
Mm-mm.
immediately. So if some interim protection is there and report be called for, madam.
Mhm.
Lordship, report may be called for Lordship.
Mhm.
As
Because,
it
madam,
says only Lordship.
in, madam, I have annexed one, annexed a tree also, madam. In this case, my lord, also was, one person, my lord, was granted interim bail, my lord.
In this case,
An extra 3 page 17, my lord.
in this case, not in this case.
Not in, other case, my lord, where FIR was not lodged, my lord.
Order of 2022, Lordship.
So, it is based on the judgment, my lord, passed by my lord Supreme Court.
That's true. That's okay. That's okay. No problem. We can also
Lordship can fix it tomorrow, Lordship. I can get the report, Lordship. From Kamala.
tomorrow. Let's tomorrow you fix many matters. Let's fix it on
Monday, Monday.
or
Lordship.
Tuesday maybe.
Tuesday. Yeah.
Full stop. Heard from and thus Marriott Council for additional people. Full stop. The petitioner is seeking anticipatory bail invoking 482 BNSS. However, he does not have details regarding registration of case, though he believes that a complaint has been lodged against him by his wife at the All Women Police Station. Full stop. Lodged by his wife, Mrigakshi Mishra. Address, full stop. It must be a 498 case.
Well, because my lord, there is sometimes what happens is, when we go to police station, my lord, they add a bigger section, my lord. Sometimes 307 is added like this, my lord. Other,
The learned counsel has also referred to the decision of honorable to page 19 আছে না তারপর উঠাই দিব এনেকে উঠাই this way it is stated that post of call for a report from the concerned police station regarding particulars of any complaint lodged by the said aforementioned Mrigakshi Mishra, wife of the petitioner, and if the case has been registered, case diary thereof may be sent, right? Case diary also may be sent if the case has been registered. However, till the next date of listing, the petitioner shall not be subjected to any coercive measure. However, he is at liberty to appear before the IO and make himself available for examination. Full stop. Leave the matter on. Let us be, we can give some time also. No issue. Friday, Thursday.
Lordship.
Next Thursday. Next Thursday will be which date? 12,
Seven, Lordship.
12 to.
5.
Map. Look at this anticipated bill FIR at page 10, Lordship. There is some landed dispute, Lordship.
At 10.
Earlier occasion also, Lordship, wife of the informant lost the FIR, Lordship, and this honorable court granted bail.
A different case.
Different case regarding this dispute, Lordship. Page 10 is the FIR, Lordship.
9%.
9 persons named in the FIR, Lordship.
Informant is. Okay. Can we read it? Let's read it.
Your Lordship. The
Inform.
informant respectively begs to state that tonight at about 6 p.m., my wife, namely Moriam Nasa, went to the paddy field, which is 1 kilometer away from our house, and the accused persons forcefully abducted her and confined my wife, Moriam Nasa, in some unknown place. There is earlier landed property dispute with the accused persons, and the accused number 1 earlier also beaten my wife due to the dispute. I came to know after the aforesaid occurrence that the accused persons armed with dao, stick, dagger, burki came on a 4-wheeler vehicle and forcefully assaulted my wife and tore apart her clothes and took her on the 4-wheeler vehicle. I am not aware about the whereabouts of my wife. And
The informant's name, this petitioner's name is same almost, no?
its informant name and petitioner name is Habibur and Habibur, Lordship. And
Father's
accused person, Lordship, that is page 19 is the
distinguished by father's name. Page 19.
page 19 is the interim order, interim granted to the other co-accused persons, Lordship. And 18 is fixed for case diary, Lordship.
Okay, we can call for the case diary and
Yes,
direct it to be listed before that bench only.
Lordship.
Some protection maybe to record
Yeah,
my
with
statement.
with some protection.
Lordship,
It will be better.
Lordship. Page 22 is the earlier bail, Madam Lordship, same person. Earlier, wife of the informant, present informant was the informant Lordship, same property and same family dispute Lordship.
Which. Hussein, right?
Lordship.
Okay, Hussein, and just learned additional people. Also. We can take it from here. Page 20. We'll stop. In support of his prayer for interim protection, the Learned Council submits that by order dated 28/1/2026, passed by coordinate bench of this court in AB 147 of 26. The petitioners, four of the petition, four of the FIR named persons
FNM.
were granted pre-arrest bail, interim pre-arrest bail, calling for the case diary and fixed on 18th of this month. Full stop. The said order in para 5, it has been noticed that some other co-accused have been released by additional sessions. Some other co-accused
Lordship.
were granted anticipatory, were released on regular bail
Lordship.
after perusal of case diary. Full stop.
He is the main co-accused. He is the main.
Call for the case diary of Dhing PS case number 309 of 25. Full stop. However, in the interim, in the event of 30,108. Okay, same conditions. Leaves the matter before the appropriate bench on 18/2/2026.
Along with Lordship. That AB 147 of 26 Lordship.
147 of 26. At a line is just right. It is submitted by the Learned Council that with regard to the same property, the wife of the present informant had lodged an FIR, leading to registration of another case in which 4 petitioners were granted anticipatory bail by this court. Will not write the number, comma, copy of which has been annexed to the bail petition. This matter on 19 along with AB number 147. Yes, that we have read.
19,
18
18,
appropriate bench.
6, 6.
Yes, tell me.
Lordship, I seek protection of anticipatory bail in the connection with the present case registered under
Yes.
section 69 and section 35 of the BNS. Lordship, on the onset, the applicant is an assistant teacher serving in the government school, namely Kogwa's Siksha Pradeep High School, Morigaon.
Okay.
And
Let me read the FIR. Okay. You need not read. It might be uncomfortable for you. I've seen some. Yes.
Lordship, kindly peruse page 21, Lordship. Statement of victim recorded under section 183 BNS and find that there are sufficient materials to suggest that accused Prosecution Sarkar has sexually assaulted the victim, Lordship. So Lordship, case diary may be called for at this stage.
Let us see. Your good name, please.
Sanskriti Varma.
As Borwa, Learned Counsel for the petitioner. Let's see how it goes. No?
Lordship, till the time could I,
Yes, yes, but I don't know whether it would be justified. The allegations are there. No?
Lordship.
Conduct is not very good.
No, Lordship, and also 183 statement, Lordship, already varies. Lordship. The
This
rejection
is
order.
arisen out of an FIR dated 22/12/25 lost by the alleged victim girl. And the full stop. The allegations include sexual abuse and sexual assault as well. The learned additional, Ms. Purva, learned counsel for the petitioner submits that some interim protection can be given while the case diary is called for and perused. However, the learned additional TPs draws my attention to the observations of the learned court below. Learned additional session judge of the jurisdictional district, referring to the statement of the girl recorded before magistrate and noticing allegations about sexual assault. So at this stage, only the diary may be called for. Call for the case diary of Morigaon PS case number 294 of 2025. Stop. We'll give you a short, because of because of some
13th
materials. I'm not inclined to give interim, but I will give you a short date.
13th, Lordship.
30, little earlier, 11th,
Lordship.
Wednesday, no? Wednesday,
Finished.
11th, no? Wednesday.
13/7.
Hmm? Oh, he might have misunderstood me. Question to mention.
No,
Yes.
affairs.
No, I had said actually at the mention that we'll take it up, so he may not have, he might have got it wrong. Question mentioned.
It is said on here. It is.
What did he mention? Do you remember?
H1 has been
After some time, maybe. After some time. He can be informed also.
Made, please, your lordship. Your lordship, anticipatory bail application, FIR is at page number 9, your lordship. And your lordship, in the same case, your lordship has granted an anticipatory bail 5 days prior, your lordship. May I read the FIR, your lordship? Page number 9.
Yes, I remember.
You need it.
It is fixed for CD.
CD, your lordship. In the meantime, it was an error, your lordship. On the last date, we applied for only one petitioner. He has appeared before the police station.
Okay.
He has made a statement, and the other one who was his friend with him, that left apart, your lordship. May we be protected so that we also go and register our information before the IO, your lordship. Same story, and your lordship, the case is that only he has not suffered injuries. The main Shahin Alam, whose AB was granted, he suffered injuries. He was with him, your lordship. May we be protected to appear before the IO, your lordship.
That's correct. Council petition and does. Page 15 or you can take it. Allegations. Page 15. It is submitted that one co-accused who had himself suffered injuries upon assault. In this case was granted interim bail by this court on 28/1/2026 in AB 157 of 26. Full stop. Full stop. It is submitted that though the present petitioner,
1 year.
one, had not suffered injury, but he was with that other co-accused who had suffered injuries. It's to call for the case diary and however in the interim, same conditions like you do. This is the matter on 25/2/26 along with AB 157 of 26.
Deeply obliged.
Nine,
Yes, Mr.
May
Talukdar.
please your lordship, my lord, this is a necessary bail, my lord.
Yes,
There are two accused in the case. One accused already granted bail by this honorable court. And the other accused is the brother.
Mhm.
Sister already granted bail.
yes.
Now 108. And
Mhm.
by commission of suicide.
Love
by-
affair with the accused number one. Elder sister. We have to see the FIR again, huh?
Yes, page 10, my lord.
Suicide. Only 16 years.
Only 16 years. And boy is 19 years. Just about 19. And there was no love affairs, my lord, exist. After the incident of suicide, my lord, 56 days later, the FIR was lost by the informant.
But after 56 days.
After 56 days, prior to that, no, nothing.
This can be-
After matrimony, it was given, my lord.
But that's okay. But there's an allegation that he had
Allegation is there.
taken some photographs. That is the only troubling part.
Rumor, nothing else, my lord.
It's only the troubling part. But anyway, let him, what do you say? Let him record his state. He's also a young person.
In the rejection order, Lordship, page number 18, the learned additional PP has objecting in granting the PAS bill by submitting that sufficient incriminating materials are found
Hmm.
against the accused person during investigation, showing their involvement in the suicide of the deceased. Lordship. So, Lordship, at this case story, Lordship.
True, but I'm only worried about, the only disturbing part, as I said, is that this viraling, this photographs.
Yes, Lordship.
Nothing was there regarding
Anyway.
to my lord.
Anyways,
If he is granted bail, everything will be disclosed, my lord.
I Talukdar Learned Council, so and as does. To page 20, probably, I got to. Who had allegedly had love affairs with the present accused petitioner. That's all. Full stop. It is submitted that on 9/1/2026 in AB 72 of 26, the elder sister of the petitioner was granted interim bail. It was justified to grant to her.
Yes.
She is the elder sister.
Yeah.
Stop. I go back to the FIR again, where the girl is stated to be only 18 years,
16 years. my lord.
16 years. And that she had a love affair with the present petitioner. There's an allegation in the FIR about that the petitioner had taken some scene photographs with her and threatened to publish the same. The learned Mr. Talukdar submits that the boy is also aged 19 years and the allegation about the photographs is false and baseless rumor.
There was no love affair.
Interim would be justified only if we do
After
not have
56.
delay in getting the CD, you know. So that's why wherever interim is given, always there should not be delay. Because we do not know what is that. This is given on some preliminary just assessment, right? Call for the case diary of Dacoity PS. However, in the interim, to enable the petitioner to record his version of events. Is is allowed to go on 25,000. It would the conditions available. He shall cooperate with the investigation, appear before the IO for recording his statement. Shall not harm or harass or intimidate the informant side and informant and their family members. Violation will entail cancellation of interim bail. This must have been disposed of then. It was fixed on 2/2.
My lord, on 17 it is fixed.
17.
And yes. Sister's case is fixed on 17, my lord. Same day maybe,
17 too. then.
17. Obliged.
Supplementary 48.
Maybe there's a lot. I'll pass over the matter for timing, my lord.
To something?
Obligement.
After something.
Bearing BA 40.
May I please to motion, my lord? Charge sheeted matter, my lord, have been in custody since 200 days. And my lord kindly said there is nothing against me in the FIR. Our name is not in the FIR. And out of nine persons who are arrested, my lord, on suspicion, out of 9, 6 have been granted bail. It is reflected in the up-to-date status report, my lord. I have flagged my. So, my lord, only on the basis of the co-accused statement, I have been implicated. Allegation is that, my lord, 15,000 rupees was snatched away at the night. Case was registered under section of Dacoity, my lord. My lord, 6 months, 20 days, almost 7 months have been elapsed. Out of 9, 6 have been granted bail. my lord.
Yes, he told me this. The case is at the stage of trial.
Trial.
Trial is
My
going on.
lord, charge is yet to frame, my lord. It's still in the my lord, stage of appearance, my lord. And
What
my
is
lord,
the- what-
regarding
What is the
case of-
matter?
It's a case of Dacoity, my lord.
Dacoity. it's-
Only,
my lord.
only, my lord, on the basis of co-accused statement. Nobody seen, my lord, nothing.
Yes, my lord,
After-
who will identify Dacoity, my lord?
After 2 months of
That's
alleged
true.
incident,
TIP is very crucial.
Can
No.
anybody, my lord?
No, TIP in all
No,
cases like this, the
TIP
Is
is my lord,
essential.
that is required, my lord. Lordship may for this aspect.
IOs must be trained. Immediately TIP.
Yes, Lordship may kindly come to page number 24, my lord. Twenty-five, 4, my lord. Lordship may kindly come to, my lord. The paragraph 6, just above paragraph 6, my lord, down below. On the basis of suspect of Arcane number PS case number so and so, BNS police of Pathakandi, PS apprehended accused Fakrul Islam, son of so and so. And on interrogation, he confesses guilt and he is involved with the Dacoity incident of this case. IO interrogated the accused Fakrul Islam, son of so and so. And during his interrogation, he revealed that he, along with the accused Jamiruddin, Santu Das, my lord, these are all the accused persons, my lord. They involved with the Dacoity, my lord. Selimuddin, Suraj Singh, and some other person whose name are not known to him. They have committed the Dacoity incident of this case on 26/5/2025. They used Alto bearing registration number so and so to travel at PO during the Dacoity incident time. Thereafter, they kept the stolen items at the house of Anguri Khanam, that is accused Zamir Hussein's mother residence located at Sarisa,
Yes.
ward number
I
1.
agree.
Further, one seizure made five MR number so and so from the accused Fakrul Islam's possession. However, the IO arrested the accused Fakrul Islam and forwarded him to judicial custody, my lord. Even, my lord, the owner of the vehicle was also interrogated, my lord, for the purpose of investigation. He said, my lord, Fakrul Islam, he has hired the vehicle, my lord.
How many petitioners here?
Only
Yeah,
one petition.
not
my lord.
2, my lord, 14 and 15, 2 petitioners.
So
Only
14 is
6 of them have been granted bail.
Granted
That is the
bail.
only issue.
under what circumstances, my lord? They
The
have
bail order is here.
All, my lord, this is up-to-date status report is there. In up-to-date status report,
Let us see that part.
I have flagged marked it up-to-date.
Otherwise, you are right, actually, because there are a lot of, that screen which we use now in POXO.
My lord.
Actually, in this kind of cases is also, it's not that in only this kind of cases, child will be in, even normal cases also, people may be scared.
Sometimes, my lord, Dacoits, my lord, they come with
Yes,
covering their mouths, my lord. At this, my lord, stage, my lord.
They
it's
will
very
always cover
difficult
their
to, my lord,
identity.
identify them in
They
TRP
will always
also.
cover their identity.
Yes, my lord, that is why, my lord, they cannot be identified even in TRP also, my lord.
Maybe, sometimes, maybe, it's possible sometimes. Sometimes, because look is of course the most important
my
part
lord.
of identification,
And out of
but
fear, my
sometimes
lord.
from other things also.
And out of fear, my lord, the people also, my lord, sometimes, my lord, they forget their.
Lot
their
of fear,
face,
definitely.
my lord.
Lot of fear. Let us see. But as you know, no, TIP followed by court identification at the time of depot trial
Before
is the
trial.
best identification evidence.
Yes, my lord.
DNA is of course different. DNA is for circumstantial evidence. That is foolproof. Where is the order? Let us see.
Up to the status.
So at this stage, you do not suggest, prosecution does not suggest.
At least, my lord, I have objection, my lord.
My lord,
Let the
I-
charge frame, my lord, because the charge is yet.
Charge
to
has
frame.
been framed,
Charge is not yet framed. my
not
lord.
yet framed.
Not yet.
My lord, I would like to.
They have been in say, custody since
Since 19/7/2025.
1907.
Since March 20 days. I humble submission, my lord, I will face trial, my lord. There is no lapse on my part, my lord. On the basis of suspicion, my lord, I have been arrested.
Heard.
My lord, I would like to place this judgment, my
Hmm?
lord. It's to place
Yes,
this
okay.
judgment.
The materials against you, this petitioner is statement of co-accused,
Co-accused,
nothing else.
nothing else.
But from the charges, my lord, it is not that, my lord, on the basis of co-accused, my lord. Even, my lord, he was arrested initially, my lord. What I am, my lord,
I will
come-
see then
got
properly.
got to know from the, my lord.
That's
Can
okay.
copy of the
To
case
counsel
there,
is
my lord.
fine. To counsel TPO, double one.
Because he is also involved in other cases, my
After
lord.
2 months of alleged incident, I have been arrested.
2 months of time. And anyway, these things also take
At
time.
almost 7 months.
We have
my
to
lord.
see
Even
both
face
sides.
trial, my lord. This is not going to be
Prosecution,
left from my part.
The invoking 48, let's see. I'm just start dictating now. Let me think also. 483 BNSS. Invoking, seeking regular bail in connection with TRC 19. No, it is not yet committed.
It's still in the, my lord, court of direct. It is fixed
Magistrate.
for the appearance stage, my lord.
Oh, then
Yes, yes.
committal, then charged. It will
Then
take some
charged,
time.
then
TRC 1957 or 25, pending before learned CGM Sribhumi, within bracket arising out of Bajari Sera PS case number 77 of 25. Full stop. The present petitioner is stated to be in judicial custody at present and was arrested on 19/7/2025. Investigation resulted in a charge sheet and case is stated to be presently at the stage of appearance and awaiting committal. Awaiting appearance and committal. The learned counsel submits that 9 accused persons have been sent up for trial, out of which 6 have already been enlarged on bail by a learned court below. Do you have the order? Do you have
My
the?
up to date status report is there.
Acha.
Yes, my lord. It is
Submitting that
flag mark, my lord.
the order would be available in the scan record. Full stop. Relying on Tufan Singh versus State of Tamil Nadu. TOFAN. 2021 4 SSC 1, comma. The Learned Counsel submits that the main incriminating materials against the petitioner is a statement of co-accused. Mr. Borua, learned additional PP, on the other hand, objects to the grant of bail at this stage, contending that charges are yet to be framed and evidence of witnesses yet to be taken.
And my lord, he has not been arrested on the basis of co-accused statement, my lord. Even if he was arrested during investigation, my lord.
Yes.
My lord,
That may be, my lord, recorded. my lord.
During
Yes.
investigation on the basis.
I'll
of
have to
witness
see then
statement.
properly. It is submitted that there are materials, the petitioner who was arrested during investigation was also done so on the basis of materials, not on the basis of adverse materials and not just the statement of co-accused. Then I'll have to see a little bit.
Yeah.
You sit down. I'll have to see it properly.
I have put a star mark, my lord, in the flag, my lord.
Yes, you're just seeing his petition first. I've perused the materials and considered the rival submissions. The allegation pertains to dacoity. Seventeen witnesses are listed in the charge sheet. His name is, what is his name, petitioner's name?
Islam.
Fakrul Islam.
Yes, ma'am.
I perused para 6 of the para 6. I perused the narration of the IO in the charge sheet regarding the present petitioner Fakrul Islam. Let's go. You have a seat. Take 2-3 minutes more. It's also revealed from the materials that during the alleged offense, the complainant was assaulted with a sharp weapon causing injuries. And rest of the some other family members were also tied up by the miscreants who had some. You have marked the order.
I have, marked on flag mark, my lord,
Flag mark.
with star marks, my lord. On the scan copy of the record. And also accused statement also there, my lord, in the case there.
One thing is also true that from the point of view of influencing of witnesses, 6 of them are already outside. That is also
Question is
there.
that, my lord, whether they are, my
Whether
lord,
keeping
implicitly
3,
against
remaining
the
3
citizen.
inside will serve that purpose, if that is the objective. Otherwise, that is the only concern.
That is
At this
also-
stage, ideally, person should be on bail,
Whether,
the stage
my lord,
of
the
trial,
penalty
but that
will
is the only concern. You
Whether the
understand? That's
penalty
the only
will
concern.
apply, my lord.
Submission, my lord, I will face
Whether
trial.
penalty will apply, my lord, in case of this petition, my lord.
Parity automatically does not
Then,
apply.
my lord, that is my
See,
submission.
parity automatically does not apply. At best, it can also, the aspect of parity again varies between the tier of the court also. You know, suppose I grant a bail, Honorable Supreme Court may not agree. They may take a different view. Same level of court, yes, it will apply more perhaps. But yes, it does not, it's not that any court, the aspect of parity applies, any tier of court, but not automatically.
And since it is a matter of certificate case, my lord, so the materials are already being collected by the IO, my lord.
My lord, my submission, Leonard.
Yes, you make your submissions.
Leonard, we submitted a statement of para 24, which is my statement, my lord. Should my statement should be implicated against me, my lord?
No, that is inadmissible.
Inadmissible, my lord. And the co-accused statement is also inadmissible. So in legal point of view, my lord, what remains? What is against me, my lord? Nothing, my lord.
But this, I am telling you this thing, from legal point of view, and this principle could also cause problems for prosecution in these kind of cases, dacoity. Because these kind of cases, they get the chain implication.
My lord.
Chain implication is there. But it is again risky. That's why this principle is
No, my lord, question is
very
that-
sound in, generally speaking.
Not the arrest.
Generally speaking, the principle is sound. Because the veracity and the of co-accused implication is always risky.
No, my
But
lord,
in some cases, the main material you will have is only chain implication.
my lord. Well, in this case, my lord, what are the other materials, my lord? Some, my lord, for example, my lord, the owner of the car, my lord, he was interrogated, my lord, for the purpose of investigation. He said that this accused person, he hired the car, my lord, which was used, my lord, in Dacoity, my lord. That is one of the aspects, my lord, that he is involved in the case, my
My
lord.
lord, the statement, I may be allowed to submit, my lord. It is a person is arrested after 2 months of alleged incident. On basis of
Yes, it will take
suspicion.
time, my lord.
The driver of the.
He gets 90 days to
That was
arrest.
used in alleged dacoity.
That I
Did
cannot
not
say,
did not say anything regarding that dacoity, my lord.
3 months he gets,
And
the
almost 7 months have been. in
investigation is always a emerging situation, right? It keeps on emerging.
So, my lord, my submission, my lord.
I have not yet found that order of bail, actually. I'm trying to locate it.
This is the up-to-date status report.
So that's
My
one.
lord, wait to the phone, don't bail it.
Up-to-date status report. Clearly,
It must be there.
It was, my lord, may I see the up-to-date status report? I have flagged my clip, my lord. All date and everything is written.
Otherwise, they are materials. They are materials seen. But the bail of the co-accused is the question of.
Whether, my lord, other accused have been granted a bail, for that, my lord, the up-to-date status report was called for, which is received, my lord. On that purpose.
Why I'm not getting,
Yes, man, I would like to place this.
I'll try once, then I'll give it to you.
Up-to-date status report. My lord. At first, my lord.
One is allowed on period of detention. Can you mark it again? I have to see that order specifically. reasoning given by the court below. Kindly check it. It is submitted by the prosecution that considering the materials and the nature of the alleged offense, the aspect of parity should not be applied. Full stop. On the other hand, the learned counsel for the petitioner submits that even if the statement of the petitioner is incriminating, the same should not be taken into account as being inadmissible. Last was considered the submission. Last one.
Into the rules. That's
Up to date status report, this one. I was searching there actually. Out of 9, 4 are on bail,
6 are in bail, someone issued,
6 are on bail, right.
6 are in bail, only 3 my lord, that is we both my lord.
Up to date, I've considered the rival submissions and perused the materials. Good stuff. And considered the matter. An up to date status report regarding the case was called for from the learned court below. And the report dated 2012-2025 was received from learned CGM Sribhum. The status is indicated in a tabular chart from where it is revealed that out of nine accused persons, 6 are on bail and 3 accused persons being Fakhrul Islam, Suraj Singh and Salimuddin are in judicial, are in custody, are in under trial detention. The present petitioner is in under trial detention since
19/7/2025.
19/7/2025.
It's 200 days today.
Upon perusing the materials, there is no doubt about some implicating materials and the gravity of the alleged offences. It is also true that the investigation, the statements of witnesses are yet to be recorded during the trial. However, as mentioned earlier, 17 witnesses are listed in the charges and cases at the stage of appearance pending committal. I find force in the apprehensions expressed projected by the learned prosecution for bail at this stage. However, the petitioner is in under trial detention since 19/7/2025, as already stated. The case is poised for commencement of trial. Thirdly, 6 out of the 9 accused persons have already been granted bail. Therefore, despite the adverse materials and the apprehensions expressed by the prosecution, I am of the considered view that this petitioner also should be granted bail at this stage, subject however to suitable conditions. Full stop. Number 50,000 with one security to the satisfaction of the concerned learned court, CGM. And subject to the following conditions: he shall not abscond, he shall be available for trial if one commences, he shall not hamper or tamper with evidence, he shall not in any manner intimidate, harass or harm the informant and his family members. Next, he shall not in any manner intimidate, harm or harass or influence witnesses. In case of violation of the bail conditions, he shall not misuse his liberty to commit any offences or illegal activities. In case of violation of the bail conditions, the bail would be liable to be cancelled. A copy of this bail order shall be sent to the concerned IO, who in turn shall furnish it to the complainant of the case and explain to him that in case of any intimidation or threats, the matter shall be promptly brought to the notice of the IO. Right? So that appropriate steps can be taken for filing an application for bail cancellation.
Very strict.
So, So the bail petition stands allowed and disposed of on the aforesaid terms. Some cases may have to take these things. They have to be informed, actually, you know. I will have to take, the police has a lot of load on the ground, but some they have to take these troubles. Sometimes then you try to balance both things. We give him a chance at liberty, but
Timing item
if he
7.
does something, then we interfere.
Item 15 by the same order, only detention 23/7/2020.
Okay, who's he? Rafiqul Islam.
Item 15.
14,
There is a
15.
co-accused Salimuddin, my lord.
Not sure, same. He's also arrested on the same day.
Same day, no, my lord, just 4 days later, 23/7,
It was like locally.
23/7. Otherwise, everything's
Everything failed except
the date of arrest, my lord.
23/7. He's in custody since 23/7. According to 19/7, it's 23/7.
Obliged.
Timing item 7.
May it please Lordship, I'm on Rafiqul Islam, Hussain. Lordship, there is a complaint against me,
Item 7.
from, Tulu Soikia.
Mhm.
He is the owner of a petrol pump. So I was working with him, in the year, since 2022. So now the complaint is that after, getting promotion, so he informed that, there is a misappropriation of, amount 10 to 12 lakhs. Now the concern is that, Lordship, there is no such complaint, from the police station. However, police called me. I, even asked the police about the case number. They are harassing me, they are calling me, but, there is no such case number I have got from them. So basically, it was inquired by my family member.
So I think in this case, it will be better to only get a report.
Yes, Lordship.
Only get a
That's-
report, my lord, and whether, my lord, whether any 35T notice has been issued to him or.
Okay.
If
Because
there is a case, my lord, then
since there is an allegation of misappropriation of 10-12 lakhs, possible
10 to
allegation,
12 lakhs, that's only.
they were not very inclined to give an interim order, prime phase.
my lord.
But you can get it early,
Report, maybe.
get the report. The petitioner is apprehending that complaint might have been filed by the owner of one petrol pump where he was earlier working,
Yes, I was working.
namely Dulu Soikia,
Tulu Soikia.
with a baseless allegation of financial misappropriation of 10-12 lakhs. Full stop. It is submitted, the petitioner denies any such allegations. He was forced to sign on a blank document,
Yes.
so we don't know actually anyway.
Even took my personal scooty also, vehicle.
It is submitted that, it is stated and submitted that the informant had wrongfully confined the petitioner, forced him to sign on blank documents and took away his
Vehicle.
scooty, two-wheeler vehicle also. Some monetary dispute maybe. Then maybe it may be justified in that case. Call for a report from the Nalbari Police Station regarding registration of any case against the petitioner based on any complaint by, say, Dulu side. It shall also be indicated in the report whether any notice on the 35(3) BNSS has been given to him, as prayed for, full stop. The same is suggested and prayed for by the learned additional people. No, that'll ulta over, I mean, to cut it about. But you can give it as a submission. Submits that will also be. But my eyes changed my view. You know, there may be some dispute. So I think some interim order will be justified. There may be some mandatory dispute. It seems. Because this is a petition on affidavit, right?
My lord, let a date may fix, my lord. My lord.
This is a petition on affidavit. So
Would not,
here,
my lord, produce the report, my lord.
Yes,
Then
sir.
we may-
till the next date of listing, the petitioner, it may be prudent to grant some interim protection to the petitioner as the possibility of the matter emerging from a monetary dispute cannot be ruled out altogether. Accordingly, till the next date of listing, he shall not be subjected to any coercive measure. Your good name, please?
A Deka.
A Dekan. Coercive measure. Then you can give a slightly flexible date. Just to take bill to Dacoity bill.
Next date is 16 March, 16 to
16-2.
16 to.
Public.
Number 16.
May I please your lordship? This bail application has filed on notice under 48. They have challenged it, and this is their fourth bail application in this court.
Fourth bill application.
Yes. So in the regard,
Never mind. So,
we want to file an objection regarding bail.
you are for the informant.
I am for DRI.
Oh, sorry, DRI prosecution. Okay. The petitioner has filed the petitioner has filed the additional affidavit, bringing on record, annexing certain bail orders passed by coordinate benches of this court, other benches,
No lordship, this from this bench lordship. The last,
or earlier rejection orders.
yes, lordship, the last rejection.
Earlier, last rejection order of the with regard to the petitioner. We'll see it again, no problem. Land counsel for the NCB slice prosecution.
DRI.
Yeah, sorry, DRI slice prosecution. Submit that they wish to file an objection. Do it, but let us not spend too much time, right?
Lordship, a date may be fixed either on Monday or Tuesday, Lordship, because already the petitioner has spent 697 days in judicial custody.
697.
Yes, Lordship.
And
and
counsel
received
submits that
some-
petitioner, and counsel for the petitioner submits that the petitioner is in pre-trial / under trial detention since about 697 days.
Lordship.
For about 697 days. When can you file the objection,
It
madam?
may be fixed for 10th of this month.
Is it okay for you? 10th?
Yes.
10th, oh, 10th is okay, no, Tuesday only. Can you file the objection? 10th or 11th? No,
10th may be fixed.
10th.
Of this, Lordship.
Time being 48.
So is the clear bill application also? Yes. Page 8 is the FR lordship.
Page?
48. 8 lordship.
Page 10,
8 lordship.
8.
Type copy lordship.
Three persons are named. in that.
No lordship, kindly see the date of FR lordship. 18/1/2026. Date of the affair is 18/1/2026.
Achha,
And the affair lordship, merit lordship.
yes.
The earliest occurrence took place lordship was on 27/5/2025. Almost lordship. 7 months later, the affair has been lost.
Okay,
Humble submission is that I had been in love relationship with the above named accused number 1 for last 4 years. On 27/5/2025 at about 3:30 PM, while I was returning back to my home from South Salmara College, the accused number 1 by inducement had taken me to a jungle at Tumni, Simla Gandhi shore and forcefully established physical relation with me. And thereafter, the local people of the village apprehended both of us and informed the police persons. And police persons took both of us to the police station. Thereafter, the guardian of both of us discussed the matter and the accused number 2 and 3
gave a written assurance before the OC that after few days, my marriage will be solemnized with the accused number 1. And had taken both of us from the police station. Now almost 7 months has elapsed, but the accused number 2 and 3 did not make any efforts towards solemnization of my marriage with the accused number 1. So she admitted fact she had a love affair with the present petitioner. And in fact, Lordship, the assurance given before the police that her marriage will be solemnized with the present petitioner number 1. In fact, Lordship, he is still below the age of Lordship 21 years. Lordship, I have annexed the one admit card showing his date of birth, Lordship, petitioner date of birth. Is 13, Lordship.
She is a minor or?
Lordship, he is not attained the age of 21 years. This is marriageable age, Lordship, as per.
20, same age.
Yes, Lordship, how he could marry. the
Is it
victim?
learned counsel, DP Goswami? Petitioner seeking anticipatory 482. South Salmara PS case 11 of 26. The informant girl lodged an FIR dated 18/1/2026 against 3 accused persons, including the present petitioner, Sohail Mahmood. Full stop. He stated to be aged 20 years. Full stop. The informant is stated to be aged, he stated to be aged 21 years. The informant is stated to be aged 20 years. The gist of the allegations is that there was a relationship between the love relationship between the petitioner and the informant. And one day they were apprehended by villagers and taken to police station. Subsequently, there was an assurance of marriage by accused number 2 and 3 of the FIR, which was not followed up. And later they were trying to settle the marriage of the petitioner with another girl. Call for the case diary from the concerned police station in the interim, in the event of arrest, 20,000 with 1 serial, to the satisfaction of arresting authority, subject to the conditions. They shall cooperate, appear, shall not harm, harass, or intimidate the informant girl or our family members. List last week of February.
26 to.
26 to.
Okay.
Short break. That is the gist of the allegation.
Yes.
Demand, torture.
Yes.
He committed
There's nothing,
suicide.
Lordship. There is nothing, Lordship. And there is no proximate act also. And they have been together for 3 months. And present petitioner is a government servant. And he has been working in his workplace. And most importantly, Lordship may see into the section, which is section 80 subsection 2 of BNS, which has been clearly stated that, Lordship, if I may read the section, whether death of a woman is caused by any burn or bodily injury or occurs otherwise than under normal circumstances within 7 years of her marriage, and it is shown that soon before her death, she was subjected to cruelty or harassment. This part, Lordship, it may be clarified with a
or in connection with dowry.
soon before her death.
It is not there, Lordship. Only the statement of sister is there, mother, that जीजा जी का घर वाला 20 लाख का डिमांड करके करते हैं और गाली देते हैं और जीजा जी उसके साथ अच्छे टाइम नहीं देता है और उसको बदतमीजी करते हैं. These are
You
the
just mark that
statement of
You just mark that statement.
Lordship. मेंटली सब लोग हैरेसमेंट देते थे. मेंटली सब लोग हैरेसमेंट देते थे.
सब लोग. Okay. You wanted to show me this section, right?
Yes, Lord.
Yes.
Lordship, on para
Satbir
20
Singh is a important case.
yes, Lordship, para 22, Lordship.
Ara 22.
May I read, Lordship?
Hmm.
It is not enough that harassment or cruelty was caused to a woman with a demand of dowry at some time. If section 304, which is of IPC, Lordship, same section, Lordship, is to be invoked, but it should have happened soon before her death.
Hmm.
The said phrase, no doubt, is an elastic expression and can refer to period either immediately before her death or within a few days or even a few weeks before it. But the proximity to her death is the pivotal indicate by that expression. The legislative object in providing such a radius of time by employing the word soon before her death is to emphasize the idea that her death should in all probability have been the aftermath of such cruelty or harassment, Lordship. In this case, Lordship, FSL has already came. And in the FIR also, if Honorable Lordship may see on page 16, they have mentioned there are physical torture. But there's nothing, Lordship. It's a completely false
Mental
FIR,
torture.
Lordship. Physical, they have mentioned in the FIR there is a physical torture in the last para of the FIR, Lordship. If Lordship has found the FIR,
Yes.
whereas it is a
FIR
completely false allegation, Lordship. And regarding, I have, in this case, Lordship, I have filed an additional affidavit with section 63 BSA certificate, where Lordship, some WhatsApp chats are given, Lordship, where the petitioner has clearly, it is just, the chat is between the deceased wife and the petitioner, Lordship. Lordship may kindly look into.
This is a conversation with whom?
With
What
the
conversation?
deceased and the petitioner.
And the petition.
And the petitioner.
Husband, wife.
Husband, wife.
Okay. Which one? The dark person?
Lordship, on 26, Lordship. On 26 and 27. Page number 27 will clarify it, Lordship.
Is the part of the additional affidavit?
Yes, additional affidavit, and also I filed the additional affidavit just to enclose the 63 certificate, Lordship. It is there in the petition.
Okay, the chats are in the
In the petition, main petition also, in the affidavit also.
This 26 is this chats between?
Yes,
petitioner and the deceased.
Petitioner and the deceased. 27, Lordship may refer to page 27, Lordship. Where he has clearly in the below portion, Lordship, of page 27, Lordship. हमको दहेज का लालसा रहता तो हम शादी नहीं करते, Lordship. He has clearly stated that.
From the statement of accused Lordship, Rajesh Kumar Kevath, he stated that earlier we got 20 lakh rupees offer from others party, but still I married her. So after marriage, we asked money from her family. It is true that I didn't give her time and not able to talk with her properly.
Let me see the diary once.
Also, Lordship may appreciate that there is no earlier FIR has been filed. No earlier FIR has been filed at any point of time.
They were
Lordship.
married for anyway.
Yes.
That could be, but also
And
only 3 months.
yes, and their point of communication is
Most
only
unfortunate thing.
only through mobile. Unfortunate incident, Lordship. Their point of communication is only through mobile phone and WhatsApp. They have neither submitted any phone records, neither submitted any WhatsApp record, because in the FIR they have clearly stated that their conversation and the demand of dowry is only through phones. Neither they have filed any FIR or FIR before her death. Neither they have intimated the police regarding the same, Lordship.
Okay, sit down. No. Wait. 5 minutes to see this. Only 25 years old. I'll see the flag portions. Sit down, Mr.
It's okay, Lordship, it's okay.
Take some, I'll be seeing carefully. His name, what is his name? Petitioner's name?
Lordship, Rajesh Kumar Kewat, Lordship.
Rajesh Kumar Dev.
Lordship, regarding the proximate act, Lordship, I have a submission to make in that regard also.
Oh, well, I'll come to that. But it is not admissible, but in his statement, he has said that he did not get money from other families, so he
There is a police statement, Lordship, recorded by the. At any time,
family members, lot of materials are there. Family members are there. They demanded dowry, they said to me, he said 20 lakhs. And she was from a poor family.
Lordship, and the petitioner is a government servant, Lordship.
That is why
There is nothing,
his responsibility is even more
there is nothing,
in society, isn't it?
there is nothing before the marriage. There is, if there was any such intention, Lordship, he would have not married, Lordship. And prior to this incident, Lordship, there is no FIR, Lordship, neither any proximate act with the petitioner, except the statement which is recorded before the police investigating officer, Lordship, which at any time it can be, Lordship, it is not admissible also, Lordship, when the trial comes.
This was recorded in 1906 during investigation. Rajesh family demanded 20 lakhs, but no such evidence. But this was prior to the, after 13/8, what are the materials? Because it's a,
Statement of witnesses are there.
after 13/8, after 13/8. Well, most of these are prior to that, during investigation. He used to work in APDCL. Right?
Yes, Lordship.
Now he is like,
He's working there, Lordship.
Anyway. Because I go to. So it is, this is a subsequent bail petition, as an earlier petition was rejected on 13/8/2025. Para 2 to law. Para 2 to law. The gist of the allegations in the FIR giving rise to the police case is uh, harassment and demand of dowry from the by the accused persons, which ultimately led to the death of the victim. Full stop. As for the postmortem and FSL report is coming.
FSR report is there.
Some death was due to asphyxia as a result of ante-mortem hanging. Full stop. An earlier bail petition was rejected on 13/8/2025 in AB 1352 of 2025. Full stop. Seen the progress of investigation after the date of rejection. Full stop. The petitioner side has filed an additional affidavit. The petitioner side has annexed some WhatsApp chats with the petitioner, with the bail petition, and filed an additional affidavit to submit a state certificate under section, it will be 65B or new section now? 63B, BSA. Full stop. There, it is submitted that some witnesses have stated about demand of dowry by the other family members. Demand of rupees 20 lakhs by the other family members. But the prosecution submits that, but no such material is with regard to the present petitioner. Though in his own statement, he has stated about some aspect of demand of money by he and his family members. Full stop. It is also stated by the IO that though there was allegation of demand of dowry, but why is he stated that? Then there are some witnesses who have stated about dowry, but he has stated that no witnesses were found. Probably is missed. Anyway,
You stated that they demanded the verbally, but there's no.
I find that the allegations of demand are more directed against the family members of the petitioner rather than the petitioner. His self-incriminating statement cannot be taken into account as it is not admissible. Secondly, the main allegation against him, one of the main allegations against him appears to be that he did not give time to the petitioner. And she was facing some harassment. In the meantime, she was facing some harassment from his family members. The parties were married for only 3 months.
Regarding the time also, I have annexed few documents.
The police has not sought to arrest this petitioner in the several months that have elapsed since the date of last rejection of his AB. Considering the progress of investigation and other aspects as indicated above, I am of the considered view that perhaps investigation may not be hampered if the petitioner is granted interim bail with conditions. Is given pre-arrest bail with conditions. Therefore, I am willing to accept this subsequent bail petition, and it is directed that the event of his arrest in connection with this case, 40,000 will once every, subject to the condition that he shall cooperate with remaining investigation appear before the IO for examination, not hamper or tamper with evidence, shall not in any manner harass or harm or intimidate the informant and their family members. In case of violation, the bail petition will be liable to be, the bail will be liable to be cancelled. Return
Deeply
back the
obliged.
case there.
Deeply obliged.
26.
এটু কি?
25.
এটু তোমার এটু connected নেই। Very good. 26. Yeah,
If it is your lordship. Lordship, can the matter be taken after some time, lordship?
after some time.
Lordship, in this case,
You are
your
for the
lordship, I am
inform-
appearing for the your lordship informant, your
Informant.
lordship. So your lordship may take it up on 9th, in the second half, your lordship, I will have to leave your lordship.
You want to leave?
Yours. Second half, I will not be there. your lordship.
You have an interim order also.
Lordship, sir.
We are on interview.
It's okay, no problem.
We have no problem.
Let's do. Learned Bhattakur, as per learned counsel for the informant, seek some accommodation and praise for listing the matter on 9th. Let's do. Case diary is received. Case diary receipt shall be retained. Interim stands extended till next date of listing. List on 9/2.
10, your lordship.
10.
10.
9 is
Tuesday-
Monday.
Monday, Tuesday,
Oh, 10/2.
10. Oblige.
27.
Wait, hold on. See, it will, yeah, I will build.
Statement to no. So lordship,
Not
in
there.
this case, we have received the CD, but
Statement not there.
statement of the accused petitioner is not in the case diary, lordship. Because
You have an interim.
Yes,
It's
interim.
not extended last time.
my lord.
I don't find the extension last time.
ডিসেম্বর দুটো আছে
On December 12th, I appeared, my lord, and my statement also recorded.
Okay.
But the updation is not here, lordship, so we have to send
Yeah,
out
it
the.
Case diary is received, but the,
Not updated.
but it is submitted that it is not sufficiently updated, comma, incorporating the statement of the petitioner. Stop. You want to return it back?
Yes,
The CD may be returned back and procured again for the next day. The petitioner was granted interim bail on 7/11/2025 and subsequently extended. But last order, it is not mentioned, extension,
I
not mentioned. So I have to, the petitioner shall continue to be on interim bail till the next date of listing. Ideally, we should give fresh, actually. If there's a very disputed case, like in that petitioner person case, some might say also that it is expired, how can you extend? Ideally, we should give it fresh, but I think it will not be like that in this case. The petitioner shall continue to be on interim bail till the next date of listing.
202.
202.
28. Number 28.
Made it was
None appears.
wait.
The report was called for, it is received.
What is the report?
No any case has been registered relating to the matter till now. With reference to the subject cited above, I have the honor to report that 17/8/25 complainants read, Burman have
PS with a written petition stating that in the year 2024 speed, this Tirachandra Borough of Jawahar Nagar, Khanapara, Guwahati took an amount of 3,50,000 from him on the pretext of giving grade 4 job. But later on, neither he gave any job nor returned the money to the complainant. Accordingly, the inquiry officer informed Sri Tirachandra Borough to appear at Satgaon PS for interrogation about the matter. But despite calling, he did not come to police station. No any case has been registered relating to the matter till now. That's the report.
Can I see? But there is a complaint.
Yeah, the complaint. 28.
After some time, you may have something to say.
Yes.
After some time or next date.
Okay, this report can be kept in a part of record.
The none appears. It's up today. However, the police report has called for is received, indicating that the complaint was filed, but no case has been registered as yet. List on.
Next week. If in this week also the lordship can.
He has an interim order. Why has he not gone? The interim order granted by order dated 4/12/2025 stands extended till the next date of listing. The record may be kept in the record. Report may be kept in the record. No, I have not fixed the date. 12/2.
12.
Report was called for, my lord, as to whether, my lord, any FIR was
Similar.
has been registered, my lord.
We have not received any report, lordship.
You have a interim order?
Interim, my lord.
Yes. Report is not received. Await and issue reminder. Interim order,
Dated
wide order dated
20
21/1.
No, 29/1.
No, that's huh? Okay. It's not, no. Yes, you're right. It was not given. Long order is last time it was given. 29/1, 26 stands extended till next date of list.
13 to 26.
13/2.
Lordship.
31.
31.
31.
All right.
My lord, I have submitted one additional affidavit.
Yes, you mentioned.
Right.
That's on the record now.
Right.
Continue.
Report lage na?
Next time.
Okay, it's
Additional affidavit.
তোমার হেৰি নেকি মুস্তাফিজুৰ ৰহমান নহয় জানো?
Additional affidavit this one.
আমি
FIR at page 27. Additional copy.
আমাক দিয়া নাই নেকি?
Copy দিয়ে আছে. Officer দিয়ে আছে. Only section is 85, your lordship. This is alternative section of 498A.
কেছটো এতিয়া কেতিয়া আছে কোৱাচোন? কেছটো লিষ্টটা কেতিয়া আছে?
Post আপনার তিনি আকৌ
Okay, in the meantime, it was filed, no? By the wife.
Right, was
498A.
498.
বতত লোৱা হ'ব? বতত লোৱা হ'ব?
খাটি গ'ল।
নহয় এইটো ফিনিচিং কৰিব লাগিব।
ঠিক আছে।
বতত লোৱা হ'ব।
He hidden his identity.
My lord.
What identity? Person,
I think
religion,
its
person,
main allegation is hiding his identity. He
As
makes
a
some relation with the informant.
religion, religion or something else.
Religion.
Religion.
In fact, my lord, since long they are in relation, your lordship. And I have annexed one bank transaction, my lord, statement at page 29, your
He's
lordship.
alleging that he's having a illicit relationship. They are married also.
Married, your lordship. Marriage certificate is also annexed, your lordship.
He did not see this marriage certificate. He has mentioned his name, real name.
My lord.
She
Their
should,
address.
she is expected to be aware of the marriage certificate, isn't it?
After filing application of marriage application before the marriage, registered marriage, my lord, the same was not verified due to intercaste religion. Thereafter, the ADC called both of them, and before the ADC, the Kamrup Metro Your Lordship, both of them stated that they want to marriage, get together, want to get a married, my lord, and they would perform their respective religion. And accordingly, their marriage has been solemnized. My lord, I will appear before the. Initially, FIR was lost before the Hazo case. Then the same
Zero
was
offense.
transferred.
Zero offense.
Yes, my lord, zero. Registered at Hatigaon PS. Your lord.
Mr. Alam, your good name?
A. Rahman.
A. Rahman, it's Ajib Rahman. Ajib Rahman, learned counsel for the petitioner, and DP Goswami. Stop. Initially, the petition has been, at the time of filing this petition, the petitioner did not have details of any case, though he had apprehension. Whereupon report was called for, and he was given some interim protection. Full stop. In the meantime, he came to know that his wife, Pranita Rajbangshi, lodged an FIR on 3/12/2025. At Hajo PS, which was subsequently transferred to the Hatigaon PS. Whereupon Hatigaon PS case number 16/26 under 85 BNS was registered. His wife has alleged that they were in a relationship where he hid his identity, but subsequently they got married. It is also alleged that he's having illicit relationship with another woman. A copy of a marriage certificate is annexed to the bail petition. Full stop. In which the petitioner has stated has purportedly stated his real name, reflecting his religion. Full stop. And the informant, being a major, has also put her signatures duly. In my considered opinion, the investigation may not be hampered. Without custodial examination and arrest of the petitioner. According, I deem it fit to allow this petition. Therefore, interim order is actually, therefore it is directed that therefore confirming the interim protection, it is directed at the event of his arrest in connection with this case. He'll be allowed to go on bail up to rupees 20,000 with 1/0, 25,000 with 1/0. The satisfaction of the concerned learned court, arresting authority, sorry, and subject to the condition that record his statement.
My lord, in connection with
Cooperate
this
with
case, your lordship,
investigation, just a minute. Cooperate with investigation, record his, makes him appear before IO, making himself available for examination. Shall not commit any harassment and cruelty upon the informant plus his wife.
my lord, the petition has come to know, my lord, same affair has also been submitted before the DCP office, Jalukbari, your lordship, yesterday from the office of the DCP.
But it will be
Jalukbari.
one jurisdiction.
My lord.
It will be one jurisdiction also.
My lord, I shall appear before the DCP office also.
In connection
They're
with this,
asking me.
that's that cannot be, a different case cannot be registered, right? Same case, it has to be amalgamated.
Amalgamated.
You can appear with this maybe.
I shall appear.
I can observe, it is submitted by the, of the Mr. Rahman Learned, it is submitted by Mr. Rahman Learned Counsel that the petitioner has heard that perhaps his wife has lost another case pertaining to the same matter. Same matter before
DCP Jalukbari.
or DCP, before the office of the DCP Jalukbari.
And yesterday, one phone was received from the office of the.
Yesterday. Good stuff. Good stuff. If the matter pertains to, we can observe, no? If the allegations pertain, are the same and pertain to the same facts, and then perhaps any other case lost has to be considered for amalgamation with the Hatigao PS case. Hatigao PS case number so and so. The petitioner is at liberty to appear before the concerned police official at Jalukbari on the strength of this order. That will cover it.
But it is disposed of or chip.
Dispose of.
Item number 18, DC.
18? He is not connected now.
Oh,
Maybe taken after some because the yesterday's matter.
No,
The last item.
today.
Lord, I am appearing in item number 18, my lord. I think my lord has kept that matter at 2 o'clock.
Yes, at 2 o'clock. The petitioner counsel thought a little time after.
My lord, I have little request. My lord, I have a request in this, my lord. I am
Yeah.
appearing on behalf of an intervener, my lord. I was there in Guwahati day before yesterday, my lord. I traveled from Delhi. Unfortunately, I'm not able to come today. My lord. I have moved an intervention. My learned friend should give me a copy, my lord, so that I can also, my lord, assist the court, my lord. So, my lord can have it. Can have it in any day, my lord. Let me be given a copy, my lord, so that I can assist, my lord.
You are appearing for the informant?
No, my lord. I am the another agreed person. There are 33 people, my lord. The total scam is for 30 crore rupees, my lord. My complaint is also lodged, my lord. So I am one of the agreed parties. So that's what I'm saying, my lord. If
So
my
you
learned
are-
friend can give,
You want to, you want to appear as a respondent, right?
yes, my lord. I intend.
Give him a copy, okay? How will you furnish? Electronically?
Yes, my lord. I will submit, my lord. My colleague is there.
Okay. Local counsel is there?
He can give me also your.
Okay. Your colleague appearing physically will
appearing-
take it. Okay.
My lord,
You are
I'll come
appearing-
physically.
Okay.
Yes,
No,
my lord. I'll
you-
come physically, my lord. May have it any day, my lord. I'll be there physically.
You want
my
to
lord.
come physically? That's
Yes,
up to
my
you.
lord.
Then can it be tomorrow, man?
No, no, tomorrow, my lord.
Monday, it
Be
may
difficult.
be fixed on Monday, your lordship.
Hmm?
My lord,
It may be fixed on Monday.
Monday also we can be
Monday.
fixed. You are connecting from which place now?
Delhi, my lord. Sorry, my lord. I was there actually day before yesterday. They
Oh, it's
mentioned, my lord, out of the turn.
Hybrid mode is available now.
Also, regarding that, I have taken instruction from my senior.
Okay. But regarding Monday,
Monday, yes, man.
because
Can be tomorrow, my lord, otherwise.
Tomorrow I have a difficulty, my lord. I want to come physically to do this.
he may not be able to come. You take the instructions. No, okay. You take telephonically. You take the instruction. You just remain connected for some time.
Yes, my lord. I will be there.
Or if you want to disconnect, it can be informed to your.
No, my lord, I am there, my lord. I am there. my lord.
I'll move on with the list.
I'll take instruction.
25.
Your lordship, I am for the applicant who had applied for VC for my senior, but he's on his legs in a court in Shillong, so I will be appearing for the applicants in this matter. I understand the matter was kept today. One more opportunity was given to produce the injury report in this matter.
Injury report received, lordship.
I'm not familiar, so I'll just see.
Nature of injury is grievous, lordship.
Your senior will appear or you will proceed? No problem. Good enough. You can do it.
Only non-bailable here is 1182.
We were granted interim earlier as well, at page 41.
I'll come to that. Can you read the FIR, please? Or I'll read it myself. I lost an Azhar. This is a complaint to the superintendent of police. Can you submit the facts a little bit? What happened was this where's the FIR pertaining to this case?
Your lordship, the file.
Rongya PS 220.
Yes, 220. Lordship, page number 27, what basically happened. is
Wait,
that-
let us read the FIR. Let us read the FIR and let them clear. Ramzan Ali, right?
Yes, sir.
Lost against 4 persons. Okay, just short FIR, let's read it.
I'll read it for you.
Yes, yes.
At page 28.
Yes.
Bulk submission is that today, 20th 9/2025, while my younger brother and I were conversing with 2 friends on the road, accused number 1 arrived there in a drunken state and assaulted my brother and me. In order to save ourselves from being assaulted, we ran away from the place and entered our house. However, after a while, accused number 1, accused number 2, accused number 3 and 4, armed with sharp weapons such as dowels, axes, knives, arrived at our house and assaulted my parents, brother and sister-in-law. Accused number 1 assaulted my mother on the head with a knife he was carrying, causing her to bleed profusely. She is presently undergoing treatment at the hospital in Sundargaon, Nalbari, in a critical condition. It is therefore prayed that your good self would be pleased to investigate into the matter and take necessary action against the accused. Your lordship, this is while our case is that these 2 people, they always stay in our privately owned premise in an intoxicated state, more or less every day. We are daily wage laborers. So what had happened is that every day we used to point them out, and on that day we happened to take our mobile phone and we started making a video. While doing that, they on altercation happened, and they informed the police first. While we also lodged a complaint, only action was taken on the complaint lodged by them in the first instance. After that, an interim order they have gotten. So we had received the interim order where we were given the protection, but after that, that was received. That was rejected on a later date. After perusal of the development of the reports and all, the medical reports are also annexed to this application, which you will see, your lordship, is that there is no grievous hurt. In fact, all the reports, all the X-rays, all the preliminary observation does not satisfy any element of 1182. And post that as well, there is no development which was pointed out to this court, which will constitute anything which is contrary to the case or will not satisfy.
Okay, let us see.
Lordship, injury is grievous, lordship. Fresh and.
The allegation is that they assaulted,
Yes.
They assaulted the mother and then his brother.
Yes, lordship.
So
statement
first
of,
you see whether the materials to indicate
yes,
lend support to that.
statement
Secondly, the
interviewed witness, lordship.
Hmm.
She stated implicated all of the 4 accused. Kindly peruse, lordship. And her photograph is also annexed.
Have a look.
Your Lordship, I was granted concession by, and after that I cooperated a daily wage worker, and then it was rejected. It's a non-speaking order without perusal of the medical reports at that point in time. After that, we had waited for this injury report since November last year.
Sure. Where's the report, medical report here?
Yes, Lordship, in the
Ah.
beginning, Lordship.
Beginning.
Yes, Lordship. Medical report it is. I have flag note, Lordship.
Oh, sorry, this one.
Your Lordship, the medical report is also annexed to this,
Previous.
which we had produced before the sessions court.
Bleeding injuries are there, blunt trauma. Bleeding injuries are there, pressure injuries. On Jaheda. Anyway. Anything else?
Your Lordship, may I please take you to page number 48 of my application?
48.
Yes, sir. This is the medical report which were placed before the sessions court, in which, Your Lordship, it is evident that there is no grievous hurt caused by a dangerous weapon, because there was no evidence of any.
But this medical
Any
report is
observation.
from, so anyway, so this is
There
from
was
Brahmaputra Healthcare. Initially, I don't know, it's not very legible. No? Right. I'm trying to read. Some medicines have been given.
Lordship, at page 49.
Doesn't seem to indicate that. Anyway. So. Sahida Begum.
She received injuries on the scalp, Lordship. So, these are the X-ray of the both hip joints. X-ray of chest, spine. But
Yes, yes.
she received injury on the scalp.
Your Lordship, those X-ray reports clearly say that there is the bone or pelvis, both hip joints show normal architecture and normal alignment. There are things as negative for fracture, negative for dislocation.
No,
There's
there
no
was
evidence of loose bodies or joints.
anyway.
There's no bruises.
You're Mr.
As Sonwal.
As home. Learned counsel for the petitioner and thus learned additional public prosecutor. Invoking 482 BNS. BNSS, the four petitioners herein are seeking anticipatory bail in connection with Rongya PS case number 220 of 2025 under so and so section. The case arose out of an FIR dated. Who's Raju Lalit? Okay. The allegation in the FIR is that FIR lodged by in Ramzan Ali is that on 24/9/2025 is that on 2025, his younger brother, he and his younger brother were talking to two friends on the road, whereupon accused number one, Rajul Ali, arrived in a drunken state and assaulted both of them. And full stop. He further alleged that when they ran away and entered their house, but subsequently all the four accused persons reached their house armed with sharp weapons like dao, axe, knives, and assaulted his parents, brother, sister-in-law. It is alleged that accused number one, Rajul Ali, assaulted his mother on the head with a knife he was carrying, leading to profuse bleeding. Full stop. It is submitted by the learned counsel that the medical documents indicate annexed to the bail petition do not indicate any grievous injuries, and the matter was pending for a considerable time for injury report to be produced by the prosecution. Full stop. There was interim bail.
Yes, sir.
Interim bail was there. He submitted the person to grant of interim. They have also appeared and recorded their statement. On the other hand, and the learned additional people submits that the case diary has been received along with a bail objection. Full stop. The medical report has been annexed as part of the case diary with regard to victim Jaheda Begum, which indicates fresh grievous injuries caused by blunt involving blunt trauma. It is indicated that there are abrasions of her scalp of size 10 into 2 centimeter and 5 into 2 centimeter, black eye, and CT scan of the brain and other tests, diagnostic tests, including X-rays, were directed. The victim was examined on the patient was examined on 209/2025 at 11 p.m. In the bail objection, the IO has stated the IO objecting to the bail has stated about the necessity of custodial interrogation and that the investigation is at a crucial stage. One photograph is available in the case diary about one lady, purportedly the said victim, with bandage on the head and clothes soaked with blood and stuff. Most of the witnesses have implicated and stated about the assault by the accused persons. All the petitioners are named in the FIR. Full stop. The victim Jaheda Begum in her statement has supported the allegations and stated about the assault upon her. Full stop. In the given situation, full stop. In the given facts and circumstances, full stop. The contentions of the IO cannot be brushed aside. Therefore, I do not find it to be an appropriate case to grant anticipatory bail at this stage. In such view of the matter, the interim bail granted earlier stands vacated. And I think there is no interim.
Your lordship, the interim was later vacated.
Later vacated, but no, by this court.
No.
Lower court. So there was no interim here. Accordingly, the present petition for anticipatory bail stands rejected at this stage. Return back the case there. Let it be, a lot of injuries. Return back the case there.
Hmm?
Should we take it up, that one? No, yeah, let us clear that. He's also online.
The informant is represented, well. How can another party come in between, madam?
The informant is represented. He must have joined.
There was no impeachment application, my lord.
No, he's appearing on behalf of informant, I think.
No, the informant is represented by a learned senior, my lord, Mr. Das. Informant, my lord.
18.
You are representing, you have to see the file then. Can you file an implement to be
I
implemented?
file an intervention.
You file an intervention.
Already, my lord, on 2nd it was filed.
Yes,
It was
acha.
not an intervention application, my lord. It was a written objection, my lord.
IA, huh?
Not an IA, my lord, an affidavit, my lord.
Okay,
To
affidavit.
the prayer for beginning.
Ah, so-
It was not an IA.
Intervention and this objection are two different things. He can file an intervention, I think.
My lord, there are around 10 other contractors who have allegedly been recorded, my lord, because we've not paid their dues.
Hmm.
Lordship will get 10 more people, my lord.
My lord, I will satisfy the court that we fall in the
That is
definition
another
of the
thing.
agree.
That is not possible, my lord.
That is another thing. The thing is that,
And we have served our affidavit that we filed today to the informant, my lord.
but he wants to be heard. No? I can hear
My
him.
complaint is before the same police station, my lord. We are 33 of them. It's a
No,
scam of a 30
I
crore
do not.
rupees.
Clubbed together, my lord. They've all been clubbed together. There is one FIR, my lord.
I have
Then
to see the file.
then I have to be heard. If my learned friends say that we all are clubbed together, then I am party.
But Sama is the lead informant, my lord.
Then you can you can sign the wakalatnama or file an wakalatnama on behalf of the informant, main informant. That you can do. That you can do. That you can do.
Lordship will hear only one set of advocates, my lord, for the informant.
I don't know the facts, but I have to see them.
My lord,
What-
may have it on Monday, Tuesday, my lord. I'll be there personally.
Wait. See, I do not know you know the facts. I do not know the facts. You have to tell me what is it about. It is about cheating. It's about misappropriation.
My lord, it is about it.
Let us see. That is how we should start submissions. This is the fact. Because I don't know. When I go to a doctor, I have to tell my complaint first, right? So what is the? Let us see the FIR first.
Sorry, the page 25, my lord. It's a lot part of it.
I won't take your time much, but I'll
Yes.
just have a look, right? So then I'll be in a better position to appreciate your submissions. Cheating and by Mukesh Jalan, proprietor of Sadguru Engineers and Allied so-and-so engineers. State that contractor 4 lane to Jorhat to Jaji. And so it's not broken. Engineers and have completed the construction work. There's an outstanding amount of destroyed. Oh, just are you familiar with the? You'll be for the prosecution. You'll appear for the prosecution. You know that there was a he got a contract, right? From 8 crore or something for the highway. Right? They are subcontractors.
No, subcontractor is the one who is seeking implement right now.
Acha.
He is not a victim.
And informant is?
Informant is one of the vendors who supplied goods to me, madam. Goods to us, madam.
Acha, and they are seeking payment. They say that
It's a contractual dispute.
their allegation is that he has received, though he has, if I've understood correctly, the allegation is that though the person who got the contract from the government, though he has received the money, he has not disbursed to the others.
I have not disbursed to certain
Payments.
vendors.
So
But
and
the
so
project work is done.
the allegation is that defrauded allegation.
Cheating, yes, madam. 420. Yes,
Okay, fine. Now I'll be in a better position
The
to.
informant is now madam Biswajit Sharma, madam.
Biswajit Sharma.
He is represented by a learned senior at T-Task. So he is well represented, madam.
No, any other person can also seek impleadment. It's not that he cannot.
Yes, my lord. My complaint, my
But the
lord,
thing
is
is
filed
that,
before this.
See, the thing is that either you can get yourself impleaded as a party respondent.
I'll
in
do
my
that, my lord.
opinion, or you can instruct the learned counsel, or you
No,
can
my lord, I
join
will.
your
Because
your colleague here who's appearing for the informant.
but I'll implead myself because I have my own document. My complaint is part of the same complaint. They owe me 20 crore rupees. Total scam is for 30 crore rupees. This is not a 2-3 crore rupees, my lord. So that's what I'm saying. I will implead myself. My learned friend should give me a copy so that I am in a position to respond to this.
Okay, you implead yourself then.
Yes,
Okay,
my lord,
I
I'll
think
do that.
you should have filed the
Not a 430 application, madam. 439 application.
you should have
483 application.
you should have filed. He's in custody.
Yes, madam. 39 days, madam.
That's anyway. So he's in. You have to file. Actually, ideally, you should have filed the objection after impleadment or through him.
Yes,
Or through him. Anyway,
I'll
whatever
do.
is happening, it's okay, no problem. Now you can, you have your say, no issues. No. But,
My lord, can I only make a request? If my lord can implement me my oral request, my lord, we will say one date. That's the only thing. Though my intervention affidavit is already there.
can it be done or no?
Yes.
What is the practice direction here? It will depend on our rules and practice direction. I have to seek guidance. Frankly, I don't know. So I've been.
I will satisfy. I will move an appropriate application.
I have been guided by my additional PP yes. So you file an implement.
I'll do that, my lord. I'll file an implement, my lord.
Without wasting much time because he's in
Yes,
custody.
yes.
Also true. Whatever it is, we have to decide, right?
Yes, yes. My lord, they were taking date, my lord. What I understand, in the last date also they took a date.
That's it. No issue.
Yeah, it is our case, but we can
And
take a big file.
Mahajan, learned counsel for the petitioner. Full stop. Who's seeking regular bail? Let me just write for reference. Another bench will also have. Who's seeking bail in connection with Tiok Pace case number 146 of 2025 under so and so section. He was arrested on 30/12/2025. Okay. Full stop. Yeah, your good name, please.
K. Bhattacharya.
K. Bhattacharya. Learned N. Das, I'll give you a name. N. Das, learned additional, learned counsel, learned additional PP, yes, for the prosecution. And K. Bhattacharya for the informant. Learned counsel, your good name, please, sir.
Jatin Sehgal.
Jatin Sehgal appears on through online mode from Delhi and submitting that he has
On behalf of my lord Shiva
some
Harlalka.
grievances to ventilate in this petition. Seeks implement. The learned counsel is at liberty to file an implement on behalf of so and so.
Shiva Harlalka.
Shiva Harlalka.
Lord, can I have a copy? Can I request my learned friend to give me a copy?
Furnished with a copy with the bail petition. We don't have e-filing nowadays. E-filing still not is there. No, he can. Is it possible to get it from e-filing? That's one of the purposes of e-filing actually. I can access. You can access. Suppose I need it in the chamber. I can
access my account.
But not to others. Yeah, some has to be. That's to be there. Anyway, so I leave it to your friend who's appearing physically. Okay. So you take it and file it. Huh?
Yes, my lord. My lord, may then give. My lord, maybe.
Case diary has been called. Okay, case diary has been received.
My lord, can we do Tuesday, Wednesday, my lord, any day? It'll take 2 working days for me to do it.
Yeah, 9th is Monday, 10th is Tuesday.
Yes,
Tuesday, my lord. Tuesday.
Okay.
Nowadays, Saturday is open in our company.
Yeah. To begin with, yes.
So 9th.
But I will love to be there on Saturday if my lord Saturday is working. No problem, bro. I will file it tomorrow only.
Just experiment. Let it be on 9th. That'll be best for you.
Can it be 10th, my lord, instead of 9th, my lord? Just one day accommodation.
I can give you on 10th. I can give you on 9th also.
My senior said that either tomorrow or 9th.
Oh, sure.
Yes, some person.
Lord, I have to be, Lord, I am in Bombay High Court. That's why I'm saying, Lord, it can be 10th or 11th, any day, one day accommodation, my learned friend, or 7th, Lord.
That I cannot say. The 9th, I've been instructed. So let it be on 9th.
Lord, 7th, 10th, 11th, one day, my Lord, I'm seeking an accommodation. Just one day, my
No,
learned
I
friend
can accommodate you. No problem. It is the council's difficulties. I have no problem.
I know, Lord. I am only requesting my learned friend. Can it be on either, my Lord, on.
If you go through virtual mode, it's not a problem.
I want to be there, sir. I should also have the.
First we have to adjudicate your. First we have to adjudicate your implement application. If it is allowed, then you come in and then we hear. So that will take a time.
I'll do that.
Okay. Let it be on 9th. It's okay. You can appear through online mode also, no problem.
Please, my lord. But then
you can get it filed. 9th you file or appear on the implement through online. Then if it is allowed, then you appear physically on the next.
On the bail, my lord. Then my lord is only for the implement on that day.
Okay. 9th.
I am grateful.
Case diary be retained. Okay, for some time.
My lord, only I can get a copy. That's it. Just my request for a copy.
You'll get a copy through your.
I am so grateful.
I may be given
through your friend on the ground. Okay.
I am so grateful, my lord.
No issues.
32.
CD not received, lordship.
Okay.
CD not.
Yes, sir. We not spend time, then issue reminder for the case diary, which is not received today. Interim stands extended till next date of listing. Fix on
16th, Lordship.
16-2.
33.
No?
33.
Your matter, same?
Yes.
here,
same,
Lordship.
same matters.
No, sir. 33 fixed for city lordship. No, no.
No, city not received.
Arising out of,
Yes.
it's a different matter.
Yes, different. matter.
Same order.
Here also. Indian.
Same order. Huh? Issue reminder for the case that interim shall continue. Let us have the same date. It will be
16.
convenient for you. 6-2.
Deep view.
6-2. 16-2, sorry.
62. 34.
Your matter, I'll just come to
Medical
it.
reports are
Hold on.
GMC no here available.
Anticipated bail petition, my lord. Altogether, there are 10 petitioners out of 10 who are granted interim protection, my lord, and they appear. And after that, cities call for.
This is also injury, no? Serious injury.
Yes, but
Why people have become so violent?
FIR is a page number 13. Constable criminal.
FIR, which,
After the Hanjwa is at 17 miles.
10%, no? Diary received?
yes, but very received.
What does it say? Came to our house and attacked my father with sharp weapons.
Medical report of the one person, Lordship Hazrat Ali, who is sustained grievous injury by sharp weapons, Lordship. Other persons were injured. Medical report is here from their skillful and blunt by Lordship. Or one person, some Hazrat Ali.
Frankly, in these kind of cases, it's actually fit for PRS bill, actually.
There are 12 persons on that accused man. So all are family members. I have narrated my another paragraph 5 of page number 7.
Fine.
Paragraph 5, page number 7. What is the actual incident happened here? There is a group case mine. How to
Out of property dispute only.
It's written also in the after there is a dispute. Case in the fire. So it is not a case where all the persons put the Hazrat Ali would shall protect my lord. Cash arises, my lord, many people who were granted interim also, my lord, they appear before the IOC.
Anyway,
Because of their age, they were granted interim protection.
huh?
Only because of their age, they were granted.
All are aged.
No. Who petitioners were granted interim protection? 1 and 5. Only because considering the age of their.
That can be made absolute, but otherwise, do you think it's a case for?
Not fit for case. Because
Because you know, as you know, of course, you are a learned counsel, you know, it's AB is slightly different, as you know. We know, we are all students of law, so it is on a slightly different footing. It's a very powerful weapon for liberty, whatever. But you know,
Do you think that there are 10 petitioners, you also may go through the evidences of the witnesses whose involvement are there, that may be look into money. Because it's a group flesh match. It is not a case where all the people assaulted a person. Only one who may be involved.
group class,
Maybe they are.
kindly see, he's right, actually. Group class, it is always risky, who's implicated, who's not.
But
Always
they entered their house lordship and brutally assaulted the
Yes.
person's lordship.
1 and 5 were given, no?
Implication.
Assaulted my lord, actually.
My implications against the 1 and 5 also there. Lordship.
Yes.
This is also stated that yes, they were there.
All are family.
One person is seriously fighting again in the hospital now at for his life.
Where is that man? I'm not going to sometimes.
I'll have a look, huh? Mr. Hussain, no? Council and TP Goswami, first paragraph. You can take from the last order, 18-12 to the rest of the. There are 2 you can just take it. The case arose out of an FIR dated 14/11 15/11/2025, lost by one Jalal Ali, with the allegations that on 2/11/2025 in the afternoon, the accused persons, the 12 accused persons named in the FIR, including the present petitioners.
Who are
In-
already arrested, my lord.
No, sir.
Those four as well. Yeah, arrested.
Including the 10 petitioners hearing, uh, came to their house armed with sharp weapons. And because of an old quarrel, attacked his father with sharp weapons. And thereafter also assaulted the informant's sister-in-law, brother, and another sister-in-law. It is alleged that they also assaulted his mother, and that his family members, as a result of the assault, were severely injured, and that the condition of his father is serious. Petitioner number 1 and petitioner number 5 were granted interim bail, noticing that interim pre-arrest bail on 18/12/25, noticing that they are aged persons. Not very aged also anyway. So let me see. The case diary has been received. Mr. Goswami Larnet, additional PP, submits that the implications revealed by the investigation, and that the condition of the said Hazrat Ali is critical and is battling for his life. But his statement could be recorded, right? Somehow.
Victim statement is
Hazrat-
there. I have flagged matter.
Hmm.
Otherwise, statement belag victim.
Victim, one of the victim has supported the allegations about the assault upon him. Peruse the medical reports available in the case diary. Stable condition, badly injured. I find force in the contention of the prosecution that it may not be an appropriate case for grant of pre-arrest bail. However, I'm not inclined to cancel the interim bail of petitioner number 1 and 2, namely Chand Mia and Jabbar Ali.
1 and 5.
1 and 5, sorry. Jabbar Ali, who have also recorded their statement, who have also appeared and their statements recorded. Their interim bail is hereby made absolute, subject to the conditions that they shall cooperate with investigation and shall not commit any illegal activities or offences. With regard to the other petitioners, the court is constrained to reject their prayer for pre-arrest bail at this stage. Return back the case there. The bail petition stands disposed of. This Marpit is 35. Not good. We should have some peace in mind.
My lord, before my learned senior friend submits, my lord, we have received a case diary in this case, my lord. And my lord, I had ordered it at 19/12/2025, my lord, the accused person was granted interim, my lord. And from the note of the investigating officer, my lord, it is shows that, my lord, he has appeared, my lord. His statement recorded, but I have not found his statement in the case diary, my lord. So may I pray, my lord, that some time may be granted, my lord, so that we can call for it, because what statement he has given, my lord.
Okay, no
that has to be
problem.
gone through, my lord.
No, sir.
Already he is on interim, my lord.
VP Soliha, learned senior counsel. Yes.
I have
Assistant
not
by-
been able to go through the entire CD, my
No
lord.
problem. Your good name, please? Amroy, it's there. Counsel. yeah, it's voluminous also.
Yes, ma'am.
You're also very busy, all of you. RJ Borwa, Learned Counsel. It is submitted by the prosecution that though the case diary has been received, but the statement of the petitioner purportedly recorded after grant of interim bail on 1912 is not available in the case diary, and he seeks to update the case diary. Allowing the prayer, the case diary may be returned back and procured again with the updated investigation, including perhaps the statement of the petitioner. The interim bail stands extended in the next date of listing. List on.
But 2022, my lord, 20, my lord, 202.
I give it on. You can give it later also. 23rd also you can give.
But 2023 to then.
23 too.
36.
Yes, tell me.
May I please, Your Lordship?
Yes, sir.
Lordship, this is substitute matter, my Lordship.
Okay.
My Lordship, the substitute matter in which my Lordship, the next date for appearance is fixed on 11th of February, my Lordship. My Lordship, I wanted to face the trial, Lordship. So I may be granted with an opportunity to face the trial. I'll face the trial without default, my Lordship. My Lordship, what happened in this case was that, my Lordship, initially I got an interim order. I have annexed that annex are 3 page 17. Then after.
On the court below.
No, my Lordship, this law,
From this-
honorable court, my Lordship. What happened is annex 3 page 17, I have got an interim order.
Yes, yes.
Then what happened was that on annex 4 page 21, when the case diary was called for, my Lordship, since I was not the counsel at that point of time, my Lordship, there was a submission from the side of the prosecution that the FR was submitted.
Oh,
So what happened was.
it
that-
was dismissed. Sir.
Yes, so I thought the petitioner was an opportunity, he was in class, FR was submitted. Thereafter, my Lordship, the
It was actually it was some miscommunication.
miscommunication. my
Actually, FR was not submitted.
Lordship, not submitted.
Then you filed this.
Then thereafter, my Lordship, after getting the notices letter, I came.
Oh,
to
no
my-
problem.
Yes, my Lordship.
Okay.
So, my Lordship, I am bringing here only to grant with an opportunity, my Lordship, and face the trial without the.
What scan record is coming?
Scan record is there, Lordship, and on the case, charge sheet submitted on here, Lordship. 31-3.
This is also assault case, no?
Lordship.
My Lordship.
11 to 26 is the next date, no?
11 point.
My God.
My Lordship, since 11th of February is the next date, my Lordship, I may be granted with an opportunity to face the trial, my Lordship. In any condition, I will not be default, I will appear regularly.
SJ Borwala, you can last order, you can take the first two paragraphs, no? First three paragraphs, you can take. It is submitted, Ms. Borwa, Learned Counsel for the petitioner submits that the next date is fixed on
11th of February.
11th of February, and
For appearance.
the petitioner is willing to participate in the trial and shall appear before the court regularly. Full stop. The scan record has been received. Full stop. Lot of injuries. Nevertheless, considering the fact that the case is poised for commencement of trial, I deem it proper to allow this bail petition accordingly. Interim was granted. No? The interim bail granted by order dated 9/1/2026 is hereby made absolute, subject to the condition that these two conditions which are already given here, they'll be there. Next, they shall not hamper or temper with evidence.
My Lordship, I have a submission to make in this regard. My Lordship, what happened was that in this matter, after the grant of interim, since my Lordship, there was a condition put by my Lordship that he will face the trial. So we were about to make an application before the trial court for his appearance, but the learned trial court was in a presumption that since my Lordship has only observed arresting authority, it does not cover the.
Oh, that's true.
So my Lordship, on his appearance, since the sessions tribal case, my Lordship, he may be.
Actually, it is once it is given.
Yes, my Lordship.
Actually,
we,
how can we modify this kind of order? You tell me. You can tell me. How can it be framed language? Yes, that's true. Arresting authority, anticipatory bail is always at the point of arrest.
Arresting authority.
Right.
But here charge sheet is submitted.
Charge sheet is submitted.
There's the trial. Let him, here's the trial, and appear before the trial court.
The arresting authority, the petitioners may appear before the petitioners may appear before the learned trial court and submit bail bonds, submit bail bonds to regularize their bail, anticipatory bail. Actually, the anticipatory bail, once it is given, you are under the cover of bail.
Yes, Lord.
Already, that only needs to be, actually, in a way, it is actually, if it is before a police, you submit the, before the police allows you to go on bail. And thereafter, when you come before the court, subject to correction, when you come before the court, you can regularize your bail by saying that I may be allowed to remain on previous bail.
Previous bail.
That's okay. But suppose you are not arrested, you are, first time you are going before the court with the order of anticipatory bail, then what will be the order? Then also we cannot say that the court will, actually we cannot give no court can give a direction actually that you will be allowed to go on.
Like session tribal, we have always said that court below will decide on merit on that.
No, that is different. That is not deciding the matter. Here we have decided the matter. I have granted bail, anticipatory bail. But what we are on is that you are very right actually, you raised the good issue. What we are on actually, how to frame the language of execution.
Yes.
That is different. That you disposed of, actually some people seek, some councils also seek that it may be disposed of. But I cannot say, if I have not decided, I cannot say to any court, that seeks sovereign power exercise. I cannot say grant bail, consider only. Yeah. So that can be done. But suppose you decide that the bail has been granted,
yes.
but how to frame the language of execution?
My lordship.
You can suggest.
Subject
You
to
can
correction,
suggest.
My lordship.
No, no,
My
we
lordship,
are-
what happens is that sometimes my
I learn from you.
opinionated benches, my lordship, we have seen, I have also done
Yes.
many cases.
Yes, yes.
In which the orders of, my lordship, we generally, a line has been added by the honorable court side that since the petitioner is on apprehension, since it is a sessions tribal case, on his appearance, he may be put to judicial custody, as such he may be granted or bail by the honorable on his appearance. Like this sort of orders are, my lordship, been passed, even in the past also several times. So my lordship, that
The petitioners shall appear before I will discuss with these things and you can always teach me. No, I'm willing to learn from everyone. Because we are constantly learning. There's so much to learn. I would like to see one of those orders, actually, a few of those other orders, the other formats, other format, but this I am disposing of. You guide me with the language.
I can give it tomorrow because
No, this I'll not keep pending. You guide me with the language.
Yes, my lordship.
The petitioner shall appear before the learned court below on the date fixed, and the learned court below shall allow the petitioners to go on bail.
Go on bail as the petitioner.
And subject and the
Most tribal matter.
allowed to appear before the learned court below and submit bail bonds in terms of this order.
My lordship.
And the learned court below shall pass necessary orders regarding the same. That's all.
That will help.
That
Pass
will-
necessary
That
orders.
will help.
Will help. That-
But this, I also have a bit of confusion on this, but still, I've seen one order also. I think after coming here only, that the court has mentioned that since it's an arresting authority, it's just given a reasoning, but so I'll accept like this. Any case law of Supreme Court on these lines? You please just find.
We'll find out.
Will
Charge sheet and
No,
maybe
no.
can be.
Gurbakh Singh, what he has said. No, that's no leading case. But after charge sheet, our question is this: let us learn. Even in other outside cases, we can learn as students of law. My question is this: see, my question is this: that when charge sheet is submitted and you will not go before the court or police officer, you will go before a court. Then execution of execution of that order of anticipatory bail and to give you that relief, what should be the language of execution? That is our question.
So lordship will provide you some documents and lordship.
Petition stands allowed and disposed of. Thank you for raising this issue because this is how we learn, The exact language. We may have some case law also, otherwise we can take guidance of.
Charge sheet I brought, my lordship, that anticipatory bills.
You have something.
That I have with me for.
Let me see one, the order. This language will do, no, for him, for her.
The language will do.
That will do, but my lordship, this will not cover this, but I brought in case if required.
No, I have no such illusion. I can always be wrong.
No, my lord.
But you have to help me to be right. It is your, both of you have to help us to be right, you know.
Language to like.
No, this is with regard to grant of anticipatory bail after filing of charge sheet. That is different, but with regard to my lordship query, I will bring some of it tomorrow, my lordship. I can give it to the.
You can just give me to my law clerk also. We'll study.
This is different with regard that it is maintaining. With regard after charge sheet also anticipatory bail.
Oh, that is
That
not
is
settled.
different. With regard to
Yeah.
bills, I'll
The how the language of execution should be framed. What will be the absolutely ideal language? You want this back? This one? No, you can take it back. This is well settled. Sundaresh, no? Asha Dubey. After charge sheet, there's no dispute.
Yes.
You can take it. You will need it. No. I have no confusion on that.
Even after issuance of proclamation also, anticipatory bail is made.
Yes, but no, PNA, I think there's some restriction.
No, Chief, that was the question raised before the Honorable Court of PJ Soikia from the prosecution side. I have brought judgments. After PNA also, it is maintained. I have that also.
Okay, but there was a judgment of Supreme Court which said that if a PNA, if a proclamation 82, see, process is one and declaration is one, you know. Process, end of process is the declaration under 82 CRPC. If the declaration is made, the judgment said that you cannot give anticipatory bail, you know, Supreme Court has said. But thereafter, there's another judgment which says that if the process is also on, then also it has, you have to be very, you know, extraordinary circumstances to be there. So if there is any recent decision, do we have to see? You will study. You will study.
39.
Don't get time to do research, but I'll love to study all these things.
Petitioner is an interim lordship. We have not received a case diary.
Okay.
It is from Hosai.
Let's go fast so that we can finish, no? We can rise. See, not received.
Not received, is an interim lordship.
Okay. Issue reminder, interim extended. List on
23-2.
Mr. Medhi, you wanted to say something? No. Hearing matter? I think it will not be possible. We also spend some time in this deliberation anyway, but we have time constraint today. So, which one you were in? 44. It's part third matter, no?
Yes, but it's part third.
What was the matter actually, this one?
My lord may recollect that regarding carrying of gold, illegal gold,
Oh,
that matter.
oh, it's a customs, no?
Yes.
Interesting point was there. Could you find something?
My lord, I couldn't find because as per my.
No, I remember, I had made notes also, I think.
Yes.
But Customs Act is
Customs will act-
not given.
will
And
not-
IPC it doesn't
will not
come.
come into play because there was no question of import or export.
And the sections given will not come according to you. IPC anyway, it was an interesting case actually, but kita bail ase, no? Let me, 2 bails are there. Finished. Well, bail we should finish now. Liberty.
42, we have not received the case. IO made a prayer lordship for 600 date for case diary.
But there is no interim here.
No interim is there.
Anybody for you for appearing? The Dacoity case. Interim may not be justified. The case there, this is wrong, no? It bhul hoise Spain. Chanmari, Guwahati Chanmari.
Not Monday, 13-2.
Monday will be
Lots of cases. We have fixed already in the next week also.
Hmm?
We have fixed lots of cases in the next week also. Lord.
Keep a track on that, because otherwise 12 or 13. 13. Case diary is not received. Issue reminder for the case diary of Chanmari. Spelling to change the bhul hoise. Chanmari PS case number 195 of 2025. Okay. List the matter on 13. 13-2.
13-2.
43.
A report was called for regarding the lodging of FIR, whether any case is registered against the petitioners or not.
That report we have not received yet, Lordship.
Mr. Azad. Mm-hmm.
A report was called for whether any case is registered against this petitioner.
What's that one? He has some interim protection. Report is not received.
Report is not received yet. Lordship.
Okay, another date from Mr. Azad. No, so the Peru's last order dated 3 Sec. The report as called for is not received. Issue reminder. Await and issue reminder. Interim order by 31. 3 Sec stands extended in the next date of listing.
17-2. 17-2.
Yes.
17.
17 you can fix a few. Well done. আৰু এটা বেছি আছে যে আৰু দুজন বেছি আছে এটাটো 18 আৰু 25 okay এটাটো রিজেক্ট হইছিল so admission matters anybody is there so I think you let us plan it then will you be able to complete sir what was your matter
Serial number 13.
18 that was the admission matter
13.
13
Admission matter.
admission matter no you have appeared earlier also this has not reached no earlier also
Yes.
you wanted to dispose of your matter also okay this 13 is one target 12 who's 12 for 12
I'm for respond number 2.
how about take a date isn't it because no we have to write otherwise we could have answered because time constraint today truncated day so
Your Lordship, I will request for our case.
I'll come to you, sir. I'll come to you. So 12, you're Mr. Jain.
Yeah, Dhanuka, for respond number 2.
Dhanuka. Mr. Jain is there, no? No. Paucity of time matter. It would have been good if he was there. Any interim orders there?
No, Lordship. It's for questioning of the FIR.
Or should any procedure? Oh, FIR. So, no interim order, right? Full stop. Mr. Dhanuka appears on behalf of respond number 2. List the matter you can suggest. Next, don't take next week. We have fixed many matters. Last week or something.
Last week, any dates as per Lordship?
Last week. 26. You can take a chance. 12. Just a minute. Your matter and your matter. You'll take some time or can you finish it?
Already.
You have submitted. Part third matters. Part third matters actually ideally should not remain lingering for long. We dispose. But at least close the argument. Then we can reserve it, no problem. And I
can finish it up within 10 minutes.
Fine. 45 is who's for 45? Okay. You are for this for today. It has come up for the final hearing or the IA? Final hearing. Final hearing. He's in custody.
Lordship,
For how long?
for more than 3.5.
Okay. And the sentence, do you remember what is sentence?
5 years.
Sentence is 5 years.
5.
He's already in custody for 2.5 years.
3.5 years.
That's urgency thing. Or we take up the AI. So please take another date. No. You can take it on a hearing day. Also, it will come chronologically.
It's a Thursday.
We can dispose of the matter, appeal itself.
Next Thursday,
Don't take it next week. Many matters have been fixed. Thereafter, you take.
then Lordship 17. 17.
17, we fix many matters.
26
Hmm?
26 look.
Huh?
26.
Then 19, no,
19 also hearing. Some cases.
is 19 okay for you? 19 is okay for you? Okay.
Lordship, okay.
Or you tell me if you prefer another date.
26.
No, not late for you. No problem. 26 Thursday. No? Okay.
Thursday. Lordship.
Okay. That day we'll try to Thursday. It will come in the hearing
Lordship.
and try to hear the. If we cannot, then we'll try to take up the IA. Okay. Paucity of time list on 26 too. So now we have your matter and sir's matter. And who's for the other side? You're for the other side. I think out of the two, we can take up only one matter. What to do? Because of the otherwise we had a lot of time. Just have a seat. Customs matter. No, to hearing too. Now I remember almost, I think almost completed. You have
Yes, ma'am. Almost completed. Item 44.
You have submitted, no, from prosecution, this goal matter. I think
I paid my submission.
you have not submitted.
Completed, my lord.
They have not submitted. You have not submitted.
Last occasion, my lord, my land polling was. So he is not available today.
Bush, sir.
So I have gone through the record as well.
You can submit. Okay. Part hard. You can, would you like to complete today?
Yes, my lord.
Complete it. One step forward at least. One eye correction from because of. Yes,
My lord, let me begin with the beginning, my lord, from the FIR, my lord.
no, I remember actually. I'm remembering now.
Yes.
There was a call, gold biscuits was found.
Yes,
And it was alleged to be contraband. That means without papers.
no, my lord, it was alleged to be smuggled.
Smuggled.
And the sections were 120B, 379, 411, 413. 420. 420, no 420, no 420. Okay, 429.
Charge sheet has been submitted.
Yes, thereafter charge sheet has been also submitted.
You are seeking quashing of the charge sheet.
Working
Entire
on the
proceeding.
Charge sheet as well as the
Entire proceeding.
Yes, entire
PRC.
PRC case. So from reading of the FIR, my lord, it is very apparent that
Remember.
it doesn't constitute any offense under section 120B, 379, 411, and 413.
They have given
Now, my
120
lord
P
has-
also.
My lord has on the last occasion raised an issue regarding whether Customs Act will come into play or not.
It came to my mind, so.
Yes, my lord. So in that case, my answer is that, my lord, basically, when the investigating agency investigated the matter, so during that investigation, if they could have found anything regarding that import or export, they could have definitely stated in their charge sheet, but they have failed to do that. So it is prima facie belief that there was no import or export, then the Customs Act will not come. Otherwise, they would have referred the matter to the Customs Agency. So,
Because as you know, all these revenue, revenue the departments.
Yes.
Not many cases on this side of the country. Some states have lots.
yes,
Income Tax Act, GST,
Yes.
customs, all of them have some criminal liability also.
yes.
For little serious, no? So that is.
And this carrying of gold bar, gold metal, or gold ornaments, anything. So whether without any documents, whether it can be a penal offense under the penal code. So there is no offense, there is no provision under the penal code that can make a penal offense under that matter. And my lord has already known the Niharika infrastructure. I am
I'll
also-
see that again.
Yes, so which laid down the very celebrated.
You
case of
brought it, you brought it.
I think yes, Bhajanlal case and the
I don't need.
RP Kapoor case.
I don't need Vasanland.
Okay.
Keep it for you. You'll need it for
Even,
other some.
even in the RP.
Niharika, I can take it out.
Even in the Niharikas, my lord,
If you want, if you have brought, I can take it.
my lord,
I'll give it back to you after completion.
the RP Kapoor case, which was in the year 1956. So it was also mentioned in the Niharika that has been laid down.
Hmm.
In RP Kapoor, it had gone little bit extended.
Niharika, actually, we go beyond Niharika because Niharika is more on FIR. Now you have a complete picture.
Yes,
The
yes,
investigation is
yes.
complete.
And investigation has been already completed. Yes,
Yeah,
my
complete.
lord is very right.
Caution and FIR is always a tricky business
Yes,
because you don't know.
yes.
Investigation is an emerging process.
Yes, but here investigation has already been completed, so nothing more has to produce
Yes.
by the prosecution or by the investigation agency.
Mm.
So from the bare perusal of all this material on record, so there is nothing in the material record that any offense can be made out under 379, 411 or 30.
You have given me case law also. Yes, you have given me already. Petitioner. Bhajanlal, you have already given me. It's okay. No
I'm
problem.
referring one, Arnab Goswami's case also, Niharika infrastructure.
Okay, that's on bail, no? Arnav Goswami's bail,
Yeah.
bail case.
But there was no crossing. It was regarding crossing also.
Oh, that other one.
Yes, that other one.
Okay.
So RP Kapoor's basically was that even if there was an allegation, even if there was a prima facie case make out, but if the evidences couldn't support it, or if there is no evidence at all supporting that allegation, then also court is empowered to quash that whole entire proceeding. So it was written by Honorable Chief Justice Gajendra Garkar at the time.
Yes, you take this back, huh? Because you need these things. You have already given me Bhajan Lal from
Yes.
Supreme today, huh? Please take
Okay,
it back.
I'll take it.
Also, this also I'll not mark. This also I'll give it back to you. I'll just have a look and give it back to you. NCD.
So that's all, my lord.
Okay, I think sufficient. I remember also. Thanks. You, another day or today?
My lord,
So he's ready for today.
if he is, my lord, taking time, my lord, then
No, I'm
I'll not,
taking
I'll
Oh,
not.
then he's
I'll-
finished.
I'll just take, my lord, only 10 minutes, my lord.
Oh, 10 minutes.
Yes,
Then
my lord.
sir is also
Because-
waiting.
Yes, my lord, yes.
No, no, there will be no time. No, we have only one, time for only one submission.
Yes.
Because it's not on me, I'll get late for
My
that.
lord.
I have to be ready.
So in 5 minutes, my lord.
Then
Then some other time. my lord.
then because-
My lord may complete it today.
then you ask sir whether
Yes.
he'll mind another day. Another day. No, huh? Another day because several days he has waited, is not reached. So next time just hold on. Maybe I'll fix it at 2, your matter, some other day.
Now, my lord, this is an application for quashing of the, my lord, searching along with the entire proceeding, my lord. Now, my lord, I am not facing any, my lord, law, my lord, because lordship is well known about the, my lord, what is the, my lord, provision, my lord, under what circumstances, my lord, if a proceeding or any search it may be, my lord, or by the FIR can be quashed, my lord. Now, my lord, saying Fazundan onwards, my lord, Supreme Honorable Apex Court is very much clear, my lord. So when the, my lord, FIR or search it, or the proceeding can be quashed, my lord. There first, my lord, there has to
No,
be
let us now
absolutely.
focus on the charge sheet more.
Yes,
Is
there
it?
has to be, my lord, absolutely no materials, my lord, or abuse of the process of court. Now, my lord, from the facts and circumstances of this case, my lord, this person, my lord, he carried 30 numbers of gold biscuit, my lord. He is a, my lord, goldsmith, my lord. Now, my lord, during checking in the train, my lord, that was recovered, my lord. It was recovered from his conscious possession, my lord. Now, my lord, if somebody carries 30 numbers of gold, that is also hiding in his, my lord, pant, under the pant, my lord. That which he was wearing, my lord. Not in a luggage, my lord. That is, my lord, definitely he has got some mens rea, my lord. Now, my lord, when the police has asked, my lord, where from, my lord, he has brought, my lord, he said that he has brought from Agartala, my lord. And lordship, may I have trademarked the, my lord, relevant statement of the witnesses, my lord, including the accused person, my lord. Now, my lord, when the police has asked, my lord, during search, that whether do you have any documents that you have purchased 30 numbers of this gold biscuit, my lord, he said that no, he could not produce. Now they have come with a quashing petition, my lord. They have annexed one document, my lord, wherefrom they showed, my lord, that incident is of 8/10/2023, my lord, when the gold biscuit was seized, my lord. 8/10/2023. Now they have, my lord, placed one document, my lord, which shows, my lord, they purchased this gold biscuits, my 30 numbers of gold biscuits on 4/10/2023, my lord. But, my lord, in the entire case diary, my lord,
4/10/23.
no, that document is not placed before the IO, my lord. If it is a part of the case diary, my lord, then, my lord, he definitely, my lord, my learned friend might have a case, my lord, for quashing or, my lord, for my lord, for any trial, my lord. But now, my lord, he has not produced this document, my lord, before the investigating officer. And even, my lord, if lordship goes by his statement, my lord, because, my lord, accused statement, my lord, I am not relying, my lord. I am relying on the statement of the seizure witnesses. Wherefrom they says, my lord, when they have searched this person, my lord, and he said that, my lord, I have carried this gold biscuit from Agartala, my lord, he could not produce any documents, my lord. That is why it was seized, investigation was done, search sheet was submitted, my lord.
That is why, in this backdrop also, I had made that query.
My lord.
That whether, whether any Customs Act provision has been given or whether it will come, because see, the IPC sections which have been given are theft
My lord.
and what else? Theft and cheating. You know, conspiracy of course may not come because only one person.
My lord, because my lord.
Unknown persons also has not been mentioned.
Customs Act might come, my lord, if he has procured this gold biscuit from Bangladesh or Bhutan, my lord.
But no section has been given.
No, because it is a clear case of, my lord, cheating and, my lord, theft.
No,
my
it's
lord.
not a case of
Because, my lord,
supplementary charge sheet
suppose, my lord, this
bringing in
person-
a customs act, right?
Yes. For example,
It
my
is
lord,
completed.
this person is a goldsmith, my lord. He knows that, my lord, he require gold for his shop, my lord. Suppose, my lord, if I go to Calcutta, if I buy a gold biscuit.
So he may be buying cheaper smuggle gold, maybe.
Definitely, my lord. Definitely, my lord.
That may be the case.
Definitely, my
But,
lord.
to prosecute someone, there has to
Yes,
be-
my lord. Now, my lord, they have come for quashing, my lord. Under what circumstances a, my lord, proceeding can be quashed, my lord?
The sections which have been given, no, 120B, you forget it. 413
is a
habitually dealing with stolen property.
My lord, because, my lord, in his statement, he has said, my lord, in earlier occasions also, he has procured, my lord, gold bar, my lord.
Actually,
Without any documents, my lord.
stolen bars are usually not stolen property. Bars can be smuggled property.
Smuggled, my lord. That is, my lord, without
Stolen-
any documents, my lord.
That was
That
the
is,
question.
my lord, when
That
the
whether, I don't know whether they really investigate this case properly, but maybe they should have referred it to the customs. Anyway, we'll not go into that. It's
My
not
lord,
my domain.
that is why
But receiving theft, theft from whom?
No,
Whom?
theft, my lord. Theft means, my lord.
There's nobody
if
has
I-
said that
if
it's
I
stolen.
purchase- if I
Receiving
purchase
stolen
a-
property.
If I purchase a, my lord, gold ring, my lord, if I wear this is different, my lord. But if I purchase, my lord, 10 gold ring, my lord, and if I carry those ring with me, my lord, and if police, my lord, asks me where from you have brought, I can say that I have brought this from Guwahati, my lord. But at the same time, I have to produce some documents, my lord. I cannot say that I have purchased from this shop. They have not given me any documents, my lord.
You have a point.
Secondly, my lord, he is a goldsmith, my lord. He knows that he will require gold, my lord, for his business purpose, my lord. Now, when he will buy 30 numbers of, my lord, gold biscuit, my lord, definitely, my lord, without documents, why he will buy, my lord? These are the smuggled items, my lord, or maybe some stolen goods, my lord. He has purchased in some cheaper price. That is why he could not produce any documents, my lord. Now, my lord, for quashing of the entire proceeding, my lord, there has to be some case, some, my lord, points, my lord, that this is absolutely abuse of the process of court if trial is allowed to be continued.
No, suppose, take an example, time constraint. Suppose we have to go to the statements. I get your point.
Yes,
Suppose we have to go to the statement. Suppose the general charge sheet.
My lord.
Suppose the charge sheet is given under 306. Suppose from the statements of witnesses, forget the medical report. Of course. There it will be very important. The statements, none of the statements suppose say about any abatement. Suppose. Then a charge sheet under certain for abatement will not be justified in this sense. So now question is that since we have to accept that since there is no subsequent supplementary investigation, supplementary charge sheet. So this is the completed charge sheet. Rightly or wrongly, these sections have been given by the IO. So we have to see whether these sections charge sheet under these provisions is justified based on the materials collected.
Yes, that, my lord, that's lordship kindly go through, my lord. I have flagged my relevant person. Secondly, my lord, charge has not yet been framed, my lord. If he, my lord, he can also produce the same my lord, materials, or he can place his argument, my lord, at the time of framing charge also, my lord. That this is my case, my lord. But he has come for
Quashing.
and the quashing of the entire
Entirety of
proceeding and of the charges.
You mean to say that he can also seek discharge?
Yes, discharge, my lord.
That option is always there.
Yes, my lord, because police has
Habitually dealing in
investigated the
stolen
matter.
property.
After thorough investigation, my lord, police has submitted search, my lord. My lordship may kindly go through, my lord, these my lord, important, my lord, statement of the important witnesses that I have flagged, my
I'll
lord.
go through it again.
And my lord, whatever they have said, my lord, what are the prima facie materials against him, my lord? So this is not a case of quashing, my lord. So my humble submission, my lord, matter may be dismissed, my lord, and I'll just rely on one decision of the Honorable Apex Court, my lord.
I was looking for, you see the definition, if you have the IPC, you open.
Yes, my lord.
That suppose stolen property, the property which has been a subject of theft, extortion, robbery, and property or criminal misappropriation, criminal breach of trust. Not conventional definition of stolen property.
My lord.
I was just thinking, suppose it was,
Even the definition of
suppose
theft, my lord.
suppose it had always, it also had this provision that which has been a subject of theft, robbery, misappropriation, breach of trust, and smuggling. Suppose.
My lord.
Then suppose the property subject of smuggling is also stolen property, suppose, definition. Then suppose 411 may be justified. Suppose if they can bring that angle that it was, but smuggling does not come in within this. It's a different offense. It's a customs offense. Anyway.
My lord, I'll just place one decision, my lord.
Okay,
I'm,
sure.
I'm not having them, my lord, hard copy, my lord.
No problem.
I'm just placing them, my lord, the case number, my lord.
Give me the name.
SLP, I'm just writing it, my lord, so it will be convenient for your lordship.
My lord. My lord, just I'll rejoin the
Yeah,
2-3 points.
you
my lord.
keep on saying.
Yes. My lord, the definition of theft, basically at section 378. So whoever intending to take dishonestly any movable property out of the possession of anyone without that person's consent. So if, yes, so there is no person who is claiming that property. Lordship has rightly pointed out that point, my lord. Next,
No, he's also not.
he was saying
He
that
fully
I didn't
understands that.
submit
All
it.
he's saying is that it should not be. It's not a case of quashing at this stage. That's
Quashing,
what
my
I'm
lord.
saying.
At this stage, my lord, it is not a case of quashing.
But you're right. The theft is who's the owner?
Yes, who's the owner? And it's a pure case of quashing, because otherwise it will be abuse of process. I will go for discharge and the court may not discharge it. Then also I will have to come to this court again. So it will be abuse of the process. It will lose the judicial time also. My lord.
For that, my lord, there has to
if-
be absolutely no
That I
materials, my lord. No materials, my lord.
If there is no material, exactly, if there is no material, then Honorable Supreme Court in various cases, it's opined that basically if there is no material, then this court has the enough power.
That is an interesting thing both of you have brought up. That what is the
Line of
difference between
discharge
quashing and
yes, sir.
there may be common areas. Interesting.
I only rely on this decision of the Honorable Apex Court, my lord. Paragraph 20, my lord, under what circumstances, my lord, a proceeding can be quashed.
Very good. Para 20, no? Thank you. Okay, so we close it. See, I have some 2-3 other matters also. So it will take 7-10 days. At least. So in between, if you want to submit some, suppose you said you miss some points, you can give me a point.
And my lord, if we
Just
have to
submit.
refer some judgments also, we will point it out and
You can give
hand
me
over to the court
a
master.
few points. Yes, you can give it. Most welcome. Since it should be reserved in, even if I had time, I would have reserved this because it needs some thinking on this. Arguments concluded, judgment reserved. Okay, thank you.
Highly obliged.
Only one matter. You let us fix a date for yourself. This matter was what pertaining to? I have not part heard, no? I have not part heard, no? This matter.
I have heard it. Mostly
heard
it is only the final submission you wanted to.
Not showing as part heard, that's why.
Interim compensation given under.
Interim compensation.
NI 143.
Okay, लिखा ना कि तो part heard से. उसका heard, Mr. the petitioner, and the matter was earlier heard.
Can you fix a new date?
I'll fix a
Your
new
Lordship?
date. The matter may be kept as part heard, full stop. What we'll do is we'll fix it on a hearing day at 2 p.m. Then it will surely reach. Because you have been waiting for couple, it should be finished. And part heard matters also should not linger. So you choose a date. Choose any hearing date, convenient hearing date. It can be on 24 to. It can be on 26 to 24 to. How about 24 to?
Can it be on Your Lordship 20? I some
24.
26.
26, no problem. 26 to at 2 p.m.
Okay.
Then we'll surely do it.
Your Lordship, I have prayer, Your Lordship.
Just
Regarding item number 12, Your Lordship.
Just a minute. No?
Yes, Your Lordship.
Just part heard go to Bolpurdi.
At 2.
At 2. Uh,
hearing guest in 26th.
For-
Item number 45 is fixed on 26th.
At 2.
Not at 2, but on that day.
That's true.
That the hearing will.
But this won't take so much time. Interim compensation, anyway. Interim order passed earlier, passed fight order 18/8/25 shall continue. Case report has come. Case report. It's come. And TCR has been received. Matter may be kept as part heard. Yes, tell me.
Yes, may I please, your lordship. Lordship, item number 12, it was heard a little bit earlier. I was at lax, your lordship. However, the matter is fixed on 26 too, your lordship.
I have not heard, actually. I have not heard.
Okay, your lordship.
I have just fixed a date.
Yeah, your lordship. Lordship, I have taken the concern of the other side. Can the matter be taken back a little bit, or maybe or second week of February, any date after 10th?
Dhanuka had appeared. Mr. Dhanuka.
Yes, your lordship.
Dhanuka. You inform him.
Yes, Mr. Ganguly, I have informed Mr. Ganguly. His senior, your
No problem. Then when do you want, when did I fix it?
26th, it was fixed on
26th also, this matter also we have
Yeah,
fixed,
yeah.
26. 24?
No, lordship,
Because
if possible on second week,
next week is very packed.
maybe there, then the week after that, not on 17th, your lordship. He said he is some urgency on
In
17th.
my opinion, take it on 24th if it's okay for you.
Lordship, can it be on 19th?
19, I don't know how many matters we fixed.
It's a hearing day.
Okay.
On 19th. So my name may be recorded, your lordship. Teach it.
Much obliged.
19th. Teach it.
Yeah, please. 19th.
19th, 1 May.
Reserved to Thailand. I'll go because I'll get hurt otherwise.
যিকিটা পার্টারর এই ইন্টারিম অর্ডার এটা আছে 20 হতে তো কন্টিনিউ হবে না সব কবি জায়গা থাকে My God, food.